So then when it says in the absence of legislative amendments, section 24.5 is the only mechanism in the RAF Act that the fund can utilize to object to the validity of the RAF 1 claim, failing which the claim is deemed to be valid as according to the SCA judgment, non-compliant claims to which the fund has not objected in terms of section 245 therefore become enforceable. And of course, that's how the judgment is given in favor of Mr. Zuko Busuku, right? So what I understand, so the judgment itself says that the Road Accident Fund cannot actually issue a management directive to change what the requirements at the first instance, right? When somebody is submitting a claim. There is actually a point where he goes further to say, quotes the judgment itself, and I need you to just opine on this. The RAF 1 form does not call for detailed information. It is not intended of itself to enable the fund to assess the quantum of the plaintiff's claim. It seeks to enable it to investigate the impact of the injuries sustained. In order to do so, the RAF 1 form requires the disclosure of information to guide and facilitate the investigation of the claim, right? But the main point of principle is whether the Road Accident Fund by management directive can simply change without amending the legislation, which is the assertion that Honorable Atkinson was saying. So if you are not aware of such conversation, we then need to ask the board and the executive management why it is that, notwithstanding a judgment and legal opinion obtained by the Road Accident Fund, we still have this over here, right? And you guys are not responsible for making those decisions. I just want to ask, if you know, do you know how many cases have arisen, like litigation, basically over this new RAF 1 form? Are you aware?
Are you
in the High Court?
Are you asking in terms of litigating for the RAF 1 or just the individual cases?
Yeah, no. So basically, in fact, let me ask this question this way, because there have been basically litigation about this. And the Road Accident Fund has actually lost, right? Some of them, at least. And where the committee should be stuck is the point where senior counsel, in addition to an SCA judgment, says you cannot issue a management directive and change the rules. That's what counsel following a judgment. The only other avenue is a constitutional court, and as I understand, did it go to the Constitutional Court?
It's with the SCHA. The current RAF 1 form cases.
No, I mean the Busuku judgment. So the Busuku judgment is case law currently. There is no other, right? It's case law insofar as where it says management cannot amend legislation by directive. That's what it says. And this form is a management directive. It's not an amendment of legislation. Can we agree on that?
So, Chair, the board notice as it stands now, the one that deals with the current RAF 1 form, and my understanding is that at the time they were issued, it was then issued by the then Minister of Transport. The current exercise that we are using in the RAF for the RAF 1 form, and I'm assuming that maybe prior to that process of what we call a board notice that was issued by the minister, there could have been directives issued. Then subsequent to that, then that process of issuing it via the department was then dealt with. And Chair, I don't want to get into.
And like I said, if you're not confident of your faith, you honestly don't need to take on a monkey that belongs elsewhere. Okay.
Yeah.
Okay. Right. So look, the only thing I wanted to ask is whether you guys were ever made aware of the existence of this, because I am going somewhere with this, and it relates to the IT project, right? It's Bukamuso, right? And when we get there, please enlighten the committee on the underlying directive that informs the mapping thereof. So it's a business process thing, right? And therefore you have to rely on what company policy says you need to do in order to adequately capture information, right? Am I correct to assume that the mapping, is there any relationship between what Project Bukamuso sets out to do, and it's a question you must answer when we get to you, and this new directive, right? Because you have to effect company policy in the directive. But the reason I'm asking this is because when we get to that, it becomes relevant to whether the expenditure of the money on a directive that is under court challenge is justifiable. Because if it gets overturned, your entire life's work for the last couple of years gets deleted along with the money. So when we get to that, we will then deal with that. The last question I want to ask is, and I am then going to just caution everyone, the reason I keep saying if things are not within your personal knowledge, please say so. We have received submissions that there was a directive not to entertain direct claims, a verbal directive at the very least. The question I'm going to ask you is, are you aware of such a directive? Because what I was reading for you, I had actually picked up from some of the submissions that we've received, that there was a time when direct claims were not being settled for a period of about 3 years for a variety of reasons. I also want to ask whether there was any process that reduced the number of sites where someone could lodge a claim. So, roadshows, whether they were reduced in number, whether you had any facilities in hospitals where somebody could walk in and facilitate a claim. Remember that earlier conversation about Nduzuma and Mkanduli and all of these things? I was coming here. So the questions are really direct. Are you aware of basically any such instruction? Because it's going to become material later on. If you're not aware, you're not aware. If you are, then tell us about it. Thanks.
Chair, the number of roadshows did reduce to a point. Why they reduced, I can't speak to that, but I mean it's observation that the roadshows were reduced, and also I think Mr. Mgwali has dealt with I don't know how long was the project, but the direct claims process that was taken within the fund was to try and trace the direct claimants and settle these things. Actually, the various regional offices of the RAF were asked to dedicate people on a permanent basis to that project to make sure that these claimants are either traced or helped through the process so that the backlog in that space gets reduced. And Chair, for as far as I can remember, when it comes to direct claims, I know of that project that was, like I said, was even people were told that there must be released permanent work in that environment. And like Mr. Mgwali was saying, that he was involved in that project. Actually, he can even give more details on what steps were taken to try and settle the direct claims and get them out of the system.
No, thank you. No, I appreciate that. I just want, as a matter of your own knowledge, and this is really what is within your own personal, was there ever an instruction not to process direct claims, as far as you know?
So, Chair, speaking to myself, I have never received such an instruction.
Okay, that suffices for us. Okay, so that is the answer. Okay, that's fine. The last point I wanted to to ask, and then we can get back to your presentation. It relates to the issue of 60, 120, 180 days, right? Because, and I really just need you to do a narration of how we got to 180 days, because it's clear that the Road Accident Fund, the time period stipulated in the legislation, I think it's, how long is it, 120? 120 days, could not be, right? And I'm not asking for a thesis, I'm really just asking for storytelling. How do we end up at 180?
Chair, I'll try the storytelling and I'll try to be very quick. So the 120 is the days we are required to settle a claim. And part of the story is that you then have that 120 days passing without the documents to settle the claim, because they would have not been submitted during lodgement, your author's report and so on. That's the first part. The 180, Chair, is that after settlement, now that there's an agreement between, after however days, there's an agreement between the RAF and the claimant or the representatives of the claimant, it will then take 180 days from date of settlement or date of court order. Then it will be 180 days for payment. So those are two things. The 120 is to settle a claim that comes through to the fund, and then the 180 is to pay after the settlement or a court order has been issued. I hope I covered you, Chair.
So wasn't the 180 days is not in the legislation, right? How does it arise?
So the 180, Chair, my understanding again is that it was to deal with the availability of funds to pay claims within the RAF, and I think there was a court process that was followed. Hence, this thing then went in front of particular judges to give the RAF a dispensation to pay claims, just the payment portion, within 180 days from a date of a court order issued or a settlement is issued.
No, thank you very much. Where are you now in terms of? Are you still at 180? Have you now managed to wrestle this thing down and you are now at 7 days? Okay, that's a bit hopeful, but you know what I mean.
So, Chair, I think we still there in terms of, from a court order perspective, the process are still on. The RAF is engaging with lawyers around that process and the stakeholders in that space, because that court order came to an end at some stage, somewhere. They say I just forgot the dates. So that's where we are with that process. Chair, I know there has been exchange of communication between the RAF and all the stakeholders that are involved. I know the board also has been part of has been dealing with trying to resolve this issue of payments.
Okay, but we're still at somewhere around 180
Yes.
days or more.
We're still there.
Okay, all right. Final question. So in the Road Accident Fund annual report, so there is an interesting graph. And for the members, is the document called RAF Inquiry Briefing, or I can't see all of it, which was sent to the members with the pack, but it's the one done by our researchers themselves. So I am looking at page 7 of 8. Okay, so I'm just going to ask for your comment. Okay, and I am going to tell you what my conclusion is out of the statistic, right? And I'll do my best to represent it because you are not looking at it. And that is in 2019-2020, the claims registered were 303,695. Finalized, 258,382. And then total outstanding was 359,190. We will all accept that information to be true. The numbers dropped significantly during 2020, and I think COVID becomes the explanation partly, right? So I would expect that to be the case. 2021, 2022, the number drops further than it did during COVID, which is 83,104, right? 2021 happens to be also the year the the RAF 1 form at the time gets challenged by Busuku, right? So the judgment is given in 2021 itself, right? The Road Accident Fund actually waits a longer time and then only obtains the opinion in February, but that's not your baby, that's somebody else's baby. Waits until February to get legal opinion on the same thing. But what we see is that virtually the number of claims registered never recovers. So 2021 is 83,104. 2022-23, it's 92,385. The number of claims finalized is 86,436. And that has fallen precipitously from claims finalized 258,300. It's literally a fraction thereafter. 2023-2024, 79,000 registered, 63,000 finalized. The interesting thing is that the number of claims outstanding basically never drops. It's now exceeding 400,000. This is from the annual report. So that gives me this picture, that notwithstanding the drastic reduction in the number of claims actually registered, you actually just never able to finalize the. In fact, if anything, the number accelerates. It's grown. It was 400,000. Sometimes it's over 400,000 now. It's 439. So it's kept climbing. Can you assist the committee with, firstly, this assertion that the drop in the number of claims registered is attributable to this RAF? This RAF 1 form, the new one, right? In the sense that the majority are rejected, right? What worries me is the following, that there appears to have been capacity previously to finalize 258,382. Now you are at 63,000. But is it attributable to this RAF 1 form, the new one, or the board that comes out of the board directive? That's the one thing. The second question that I've got is whether you've got any insight into why it's remained difficult to settle or reduce the number of outstanding claims. And as I understand, that should be the people that Mr. Mkabela said you are busy phoning. The final thing I want to ask is that the average per claim paid has actually continued to increase. As of 31st, this is also from your own internal documents. In 2019, let's say in 2019, 2020 was 2019 was 114,000, 2021 38,000. By 31st of March last year, it was 286,825 per claim. So you see the mathematical problem that we now have. You used to be able to settle, to basically finalize 258,382 one way or another. Now you're finalizing 63,000, but you are paying more. Can you give an insight on that? I'm trying to understand why that would be the case. I'll leave it there. But from a value for money perspective, if you're able to settle at a lower average, sure, I can get, but there might be an explanation that I don't know about.
Chair, I suspect I'll find it difficult to speak to those numbers, and if I had them before so that I can understand what could have happened. When I hear you speak about the drop in registration, what I presented also showed that fact that the RAF 1 obviously reduces registration of claims based on non-compliant claims. That's a straightforward one. In terms of the and then the settlement.
Sorry, so in other words, in terms of the board directive, and it is important, I'd like the members to note this. So in terms of the board directive, those claims are non-compliant.
Yes.
Right. Let me ask this question, it's very important. If if the courts decide finally that this actually new directive is not compliant at all, it just cannot be used, right? Is there somewhere where those claims you rejected are registered and kept so that you can, because you will have to unwind that mess? Have you kept it somewhere?
So the pre-assessment system where these claims are pre-assessed, Chair, they are then identified, even though they're not registered within the organization.
Okay, so they're registered. I'd like the Secretary to record that as an accounting issue to raise at a later stage, okay?
Chair, I'm saying even though they're not registered, but you're sure.
So please proceed in terms of my initial question.
Chair, the other questions are going to just be challenging because of the numbers that you've been speaking about. But I think I need to mention that part of and because you're dealing with numbers, and for me to speak with the mathematics that you're speaking to, I might just find it a bit of a problem. But I need to speak with two particular principles as well. I think there's been an attempt by various offices of the RAF to try and settle claims. I think you'd have known about block settlements and so on, where people interact with law firms to try and settle claims. And equally, I think there are claims that actually I know there are claims that even though you try to settle because of, again, missing documents, so there's a balance there, Chair. There are people that are having claims that are ready to be settled, and we have teams that are looking into those and try to settle them. Of course, because of the volumes of numbers that we have, those will obviously have to be taken through a particular process and taken through a particular queue. And that's why we're running settlement drives across the country. We have launched one, I think, recently now in Pretoria, and Durban has gone live with a settlement drive. But amongst those, you are going to find claims that we cannot do anything about because we don't have the required documents for those. So that number has that balance within that. Claims of people that are ready, that are saying, I've given you documents, I just want an offer and do away with this thing. And then you've got claims where we really cannot do anything about because we also have, we were looking at it recently where you can't even trace the legal practitioner. So we have divided these things into the buckets. I think the chairperson of our opposite committee had asked that we break down all the claims that we have in the system so that we can, explain each pocket to say, in this pocket, what is the issue? So we've done that breakdown, Chair, and you find those where you are saying not traceable, the others, people want to settle. The others are going through mediation and so on. So we've done those kind of buckets.
I had asked about the satellite, you remember that question, about satellite offices and that kind of thing. So, yeah.
So there was a time where RAF has had hospital service centers, and they are not in operation as we speak. What I cannot speak to confidently, Chair, is the reasons why those things were paused in the meantime. I just know that there was also an issue about touting in hospitals. I cannot say it is the reason why there was closure of those, but of course, I think your statements are correct that there was a closure of those hospital service centers, which is something that is being looked at now to re-look into. Like I said earlier when I presented that we are testing the channels that we can expand into and look into. But your assertion around that is correct that there was a closure of those. And I can't just speak to the real reasons at this stage because, yeah.
No, thank you. But part of why you are here is also to help us understand what information to ask the board for from the RAF. So honestly, if you don't know the reasons, it's really not a crime if it's not in your personal knowledge. So the picture that's emerging is the following. So because I'm trying to get to the drop in the numbers. So the road shows reduce for whatever reason. The number of satellite offices, for whatever reason, reduces. The threshold for submitting a valid claim goes up, right? In that you now definitely need a lawyer. If you didn't need one, you now need one. And even they are struggling, right? That's the picture that's emerging. We can't, I don't know if you can deny, but that's a picture that's emerging. And what we end up with is a picture where it appears that people aren't submitting claims, or the majority of claims. If I were to reverse explain what's going on, basically, historically, you were entertaining claims you should have never have entertained. And I don't know, and that's part of maybe the information we need to ask for, which is what is the possibility for that these people that have been rejected should have been. But what is apparent to me is that there is a funnel which ends up with the number of claims registered being small. And there's a series of decisions taken. Reduce the number of places where someone can walk in and submit a claim, such as your satellite centers. Reduce the number of road shows. Then you have a situation where the threshold for submitting a thing twice in just over 18 months. One is overturned by a court, then there's a new one. And you end up with a situation where the number of claims that are registered is quite small. Meanwhile, the amount of money the Road Accident Fund pays per claim doubles. Those figures are from the Road Accident Fund annual report, and I told the members which document. I'm not asking you to explain it, but that's a picture that emerges so far. Can I just, I don't know if the members have any questions. If not, I'm going to ask you to just go to the slide. Yeah, and you can, by the way, add or comment on any of what I've said, and I like that you are doing so. So please comment. I'll ask the members if they've got any questions, then we deal with the litigation issues.
And Chair, I just wanted to indicate that the customer service centers were not reduced. It's just the hospital service centers. I just wanted to make that distinction. Actually, there was a view that the customer service centers should be looked at and see if they can be increased, but definitely the hospital service centers were closed.
No, thank you. That's helpful, by the way, because we can ask for specifics from the board. So thank you very much. That's really helpful. Okay, members, do you have any questions on this? Because we're going to go to the slide on where do we get to the court process. Okay, sorry.
To check, Chair, if we're still going to have comments at the end. Or remember before the break we said we'll defer it to after break.
Yeah, that's why I'm inviting. If you've got comments or questions, you can. No, that's why I was asking.
No, after the slide.
After the slide. Okay, no, that's fine. No. That's fine. Okay, thank you. Can we then go to, that one, the litigation. Thank you.
Chair, I think, and again, the response to this was based on at least what was asked as part of the orientation. So one did not really go deep into the details of how litigation works, but I think the question wanted us to compare, at least from a process perspective, what happened when there was a panel of attorneys and what happens when there's a state attorney. So essentially, from a process perspective, it's the same, because what would happen is that when someone comes, a panel attorney would have been allocated to defend that someone, and then they would then deal with that process. And then the panel was replaced with state attorneys. So when someone comes now, it then gets allocated to a state attorney. So an instruction that used to go to a panel is an instruction now that is going to a state attorney. And I think, Chair, that's, and again, in terms of storytelling, I don't want to go into defining each of the boxes, which was the intention when we drew them. But I think the fundamental question was is there difference in process? From a process perspective, no, there's no difference. There was panel, someone comes, it gets given to a panelist an instruction went to a panel attorney. Now an instruction goes to a state attorney.
Right. No, thank you. Let me, okay, Honorable Nilmay, please go ahead.
Yes, no, thank you very much. That particular statement I'm very interested in, because somewhere in our documents I was perusing yesterday, it said that you had appointed some attorneys and then seconded them to the state attorney. Is that right? So you missed that part. So the attorneys that you had, well, I'm not sure if they were part of your previous panel, or where they fitted in, but then you seconded them to the state attorney's office. Did you then, okay, that's the one question, why? Secondly, were you paying their fees in the state attorney's office?
Chair, and I think My worry, Chair, is that I think we're delving into documents that were submitted that must be dealt with by in a particular period. My brief was not to deal with who got paid.
Let me ask this, Honorable Neil May, and you in this way, right? So if you can just switch off your mic and just say if my reading is incorrect. So basically, the Road Accident Fund, when it did away with this panel of attorneys, it then used the panel of attorneys of the GEPF, correct? No? If you're not sure, you're not. But there's an MOU between the GEPF and the Road Accident. But basically, the consulting firm of the Road Accident Fund becomes a state attorney, basically. Instead of you use the state attorney to brief counsel, basically. Is that correct?
Chair, you mean how it's happening now?
Yeah, no, not now. So at the time, right? So when you did away with your so what? Do this. If a matter needed to be litigated, you would speak to someone in the legal department. Just explain how that works, and really in layman's terms, right? There is a dispute about how much should be paid, for example. The Road Accident Fund disagrees. Its own experts have said, no. You can actually start working in a year's time, not in 5 years' time. We're not going to pay you for the next 5 years. The claimant disagrees. They think they need to be paid a loss of income for 5 years, right? And this is a hypothetical. So there's a disagreement. Where does that matter go? So previously, before the state, would that go to your legal team to handle?
So, Chair, it will go to a state attorney that is representing the RAF to go and argue it in court.
So they would then go and argue it instead of getting an advocate to do so. So they've got the right to appear before the court, and they would go and stand up and argue the matter. So that's how it worked then. Or is that how it still works?
So, Chair, remember there was a time where there was panel, and now we're using state attorneys. So I don't know how panel operated, Chair. I must be honest with you.
Okay. No,
but in terms of the current process, most state attorneys go and argue matters in court. There could be cases where they decide that there must be complexity, they appoint counsel. But as we stand now, most state attorneys appear in court to argue RAF matters.
Okay, no, that's fine. That's what I wanted to know. And your colleagues are concurring. Honorable Neil May, does that satisfy your question?
Not really, Chair.
Oh.
Because the attorneys that they seconded to the state attorney, because what I read, it said they were seconded to the state attorneys. Where did these attorneys come from? They were part of your register of attorneys that you then seconded to the state attorney to then act on with the state attorney's office. That is what is in the documents. So my question is, who were these attorneys? Were they weren't the panel that was there before, but they were some attorneys that you had on your books, okay? And they were seconded to the state attorney's office. And my question was, how? The one, because I think that maybe that's in the AG's report, Chair. I'm not sure, the AG's report. But the second thing is, who was then paying for those attorneys? Were they then sending the bill? Was the state attorney sending the bill back to you? Because how did that manage? Were you still paying those attorneys? And if you had an MOU with the state attorney, you know, at the end of the day, you were still paying attorneys, but now they were part of the state attorney's office or whatever, because it said that the Road Accident Fund had seconded attorneys to the state attorney's office. There. Thanks.
Are you familiar with this story?
You know, Chair, I am, but also I must be careful of what was submitted by people that submitted the documents that they submitted.
Yeah, that's what I am concerned about that. And the reason I'm asking you by way of a narrative is so that you can say what is in your. So just narrate the story. What we wanted to know here is this, okay? How do you decide? So what determines that a matter is to be litigated? And I'm assuming that there's a dispute between yourselves and the claimant. The claimant disagrees with your own conclusion. Then it goes to court. So all I wanted by asking for this section is what then happens by way of step 1, 2, 3, 4, that basically the instruction goes this way and it ends up there. That's all I wanted to know.
I think the slide deals with that, Chair. So the panel was using what we call the litigation management system. And I think, and again, I must say I was not there when the panel was there. But what I understand is that, and colleagues would assist me, is that when a summon is issued, a matter will be issued to an attorney. Then when another one comes, it goes to another attorney. That is the panel era. So the same model has been applied, where now we've got state attorneys that are on record on behalf of the RAF. So whenever a summon is issued, because once a summon is issued, there is an intention to litigate. And then a state attorney gets allocated, the next one gets allocated. So a similar process is being done. And hence my submission was saying that allocation would have in the past went to a panel attorney, or rather a firm, a particular firm, and there were various firms, but now it goes to a state attorney. Yes.
And then the attorney argues the matter in court themselves, but if it's complex and it needs counsel, then the state attorney engages counsel to then litigate the matter. So the only thing that has changed between the panel and when there was is literally who the file goes to. It now goes to the state attorney rather than.
Most matters of the RAF are argued by state attorneys themselves,
which was not the case before when you had a panel. Or just you are educating us, so
Chair,
it's not a trick question.
When I want to deal with what panel was doing and how they were doing their business, so I would not know whether the ZB attorneys would send their own attorneys or they would brief.
No, that's fine.
My suspicion, colleagues must confirm those that might have interacted with the process. My suspicion is most of the times counsels will be briefed, and the key issue here, Chair, is suspicion. And I don't know, colleagues. So I would not know how ZB Incorporated would be sending people to court.
No, you don't need to. So basically, it's handed to the attorney must handle it. That's all you need to tell us. Okay, so that's now being done by the state attorney, and the state attorney may then decide to engage counsel depending on the nature of the matter at hand. That's okay, no. But fundamentally, the process internally remains the same. Okay, all right. Honorable Member.
Thank you, Chair. I just wanted one more clarity, because at the center of what we're doing, there's a huge complaint about the non-renewal of the panel issue. And it's made an issue when it's not an issue, by the way. I want to check now with these new allegations, which you are seeking to clarify. The state attorney, once they get the file, they do not get then to seek assistance from you in terms of beefing up. Let's just say he has 4 matters appearing in one day. So doesn't he come back to you to ask for assistance in terms of representation in those different courts? Or he or she takes that matter to his office and then he dispatches and make deployment from their office without having to burden you with extra cost of lawyers and all those things. That's just one area that we must clarify. It must be clean, because here the number of the matter is that the panel was removed without a plan. Now we need that clarity that there was a plan, the state attorney is there, and it doesn't cost us more. So please.
And so Chair, thanks for that. So Chair, when I make reference to state attorney, and at least in my head, I'm talking about particular individuals. And I know there's a question of the state attorney office. So when instructions are given to a particular individual in the name of an attorney called TEP or attorney called Zibi. And again, I think I emphasized to the chairperson of SCOPA that in most cases, state attorneys go to court themselves and argue these cases. They hardly involve the usage of counsels. They go and stand in front of judges and fight cases on behalf of the RAF.
I saw a hand. Was it you, Honorable Madlala, or not? Oh, sorry, Mr. Mkabel. I've got a friend with the surname Mkabel, so that's why it's so easy for me to remember your surname.
Thanks, Chair. I don't want to waste time, but I just want to add to what my colleague has said. As is indicated, the process hasn't changed from the old panel to the state attorneys right now. What we have started is a new regime, so to speak, which we are building, by the way. It started not so long ago, and it's going to take us a bit of time to hire as many of those state attorneys, to the extent that we'll begin to feel comfortable that we've got sufficient cover across all our areas where we host our operations. So we are building, and it's a matter that the current board, the interim board, is seized with to drive the recruitment of those attorneys to make sure that at no day should the RAF matter not be dealt with without a state attorney being there. So I think we are in the building process as part of the broader transformation or building up the new RAF that we want to see. It's going to take time, but of course, we still have those teething issues that we inherited in the past that we want to address. Thank you, Chair.
No, thank you very much. So just so I understand, so the road accident fund, as I understand, cannot have a staff member appearing in court to defend it because they are conflicted, right? So the representative of the road accident fund needs to sit outside, and that outside place is the state attorney. Am I correct? And therefore there is an, please correct me, I'm just making assumptions here to simplify. There is an MOU between the road accident fund and the state attorney that says we will make resources, money available for you to hire such number of attorneys as is possible, so that when these matters at the end of this process need to go to court, they may then handle those files and go to court and argue them. But to answer Honorable Neil May's question, therefore, you are resourcing that. So it's not money from the Department of Justice and Constitutional Development, it's Road Accident Fund funds, which you otherwise would have been using to, whatever, right, to pay a panel of attorneys. You've decided to rather use the country's law firm, which is the state attorney, right, in order to, so that's, in simple terms, that's the strategy here. I represented it correctly.
That's correct.
So I'm hoping that Honorable Neil May then answers your question, which is the RAF makes the money that hires the people available to hire them.
Sorry, Chair. Chair, this is how it is. The fund, the RAF fund, employs suitably qualified and admitted attorneys, and they will be placed. So it's your attorneys that you have procured, and you have seconded them to the state attorney's office. That is what is in there. And the fund shall be fully responsible for the costs of officers, administration, or other related expenses. So it's attorneys that you have employed, suitably qualified and admitted attorneys that the fund has employed, that you've seconded to the state attorney. And that is the memorandum of understanding. I just managed to pick it up now.
Okay.
But I did read it in our other documents, and that is where the question was. If they have actually, you proceeded to not have your panel of attorneys, yet you had attorneys that you have on your that you had employed, and then you took those attorneys and you seconded them to the state attorney. That's how it is. Which is what is the question is, why would you do that? What was the reasoning behind that?
I don't want to become a witness. My understanding from their explanation just now is that the reason this arrangement is in place is that previously they would have had to get an external law firm, and those law firms they bill per hour, whatever the case is, and these are people that are at the state attorney's office, and they get paid a salary to appear as many times as they need to appear. And in the determination of the road accident fund, that is more cost efficient than the other option, which is to send the matters to law firms. I see your hand is up. So I understood that to be a submission, and therefore what I think is causing the confusion is whether the people are RAF employees sitting at the state attorney, or the road accident fund gives money to the state attorney to hire people on its behalf. That distinction. She is saying in her reading of the memorandum of understanding, it says these people are actually road accident fund employees. They just sit elsewhere at the state attorney's office. Which one is it? I think that's a clarification.
And Chair, I think I dealt with this. One, I must submit to the committee, this kind of a question is not part of the brief. And I would have dealt with, if it was part of the brief, I would have then gathered proper, you don't want to contradict what has been submitted in documents that members are reading.
No, don't worry. I have said to you, we gave you a certain brief. If something falls outside of that, do not be afraid. We will still ask the question of the board and have that information provided to the committee. So don't feel obliged to speak to things you are not certain about, lest you are said to have misled the committee. So I want all of you to remember that.
So Chair, the answers that we've provided around what state attorneys do, especially when you're asking, are they briefing counsel, are they going to court? We can confirm that most of the time they go to court. In many cases, they go to court. But how the arrangements are done in terms of the MOU, how do we interact with the Solicitor General? I think the submissions from the RAF that addresses those kind of questions.
Okay, we'll note it, Honorable Neil May, and get an answer accordingly. But I'm happy. Okay. Oh, sorry, Honorable Atkinson.
Thanks very much, Chair. Just a question really about the state attorneys and the fact that they are defending some of the road accident fund claims. Is there any limitation that you've got from the state attorneys? I mean, how many actions can they do in any one day? Because I'm getting an indication that you're only allowed to have one a day. Are you allowed more than that? And obviously the state attorney needs to do a whole lot of other things as well. So they can't have their entire capacity taken up by the road accident fund. So I was just interested if you can comment on that as to whether you are limited by the state attorneys as to how many actions you can cover. And also how many...
So Honorable Atkinson, for clarity even for me, so when you say one a day, one what?
One action per day.
So basically each attorney can only have one case that they are handling per day?
Per day, yeah.
Okay, all right.
Or yeah, that's my understanding of it. State attorneys, yeah. And also, I was just wondering how many cases have you actually briefed the state attorney on in, say, the last year? I'd just like to get some indication of your use of the state attorneys to defend claims. Thanks very much.
Chair, the issue of one matter per state attorney, there was an issue with I think mainly, I must say, the North Gauteng, is that how it's called? The North Gauteng court.
Can't keep up, they keep changing them. Pretoria.
The Pretoria court, mainly, they had this issue that a state attorney cannot appear on more than one matter. and I'll leave it there, Chair. But in terms of how state attorneys get allocated to litigated claims of the RAF, and I don't have the numbers, but if there's an issue of litigation in the RAF, it will be allocated to a state attorney.
All right. So basically, if we want further information, we'll just ask for that information. Okay. Thank you very much. Okay. I'm okay with how this process works and so on. So can we just deal with contracted medical experts? And I think when you were explaining earlier, you actually brought us nicely to say, and maybe it might help now with the new procedure, right? But at the time you had explained it nicely to say, you would have your own people checking if this person really broke a leg in a car accident or they were murdered by their friend somewhere else, right? So understood all of that. So can you just give us a lay of the land of this? Do you have a panel of experts? Is it like something that you actively manage internally? I think you did a good explanation of what they do. I get that. But just tell us how this whole thing is managed, they are paid, etc. On both sides, by the way. What I'm keen on is also, is it that when I claim via an attorney, some of those expenses are then itemized as things that the Road Accident Fund must pay nonetheless or not? So if you can just educate us on this whole science here. So
Chair, and I'm gonna try your guidance on storytelling. So I'm not gonna go through the slide. And I must disclose that currently our panel is expired. There's a process to get the new contract finalized. So, but when we have a panel, remember in the past again, the panel of medical experts would have been mainly appointed by the panel of attorneys then, before when there was a panel. They would be the one that were deciding on appointment, or rather interacting with the panel of medical experts of the RAF in terms of people that needs to be appointed. But currently then it's a process that is done internally within the RAF. So during a claims process, if then some of the claims teams in all the regions assess a particular matter, and then in consultation with attorneys or in consultation with medical teams within the fund, they feel that we then need to appoint experts for particular claims so that we've got a case in court. That process is now done internally, because the question that was asked was, how was it done in the past and how is it done now? In the past, the panel of attorneys would mainly be driving the appointment of experts on behalf of the RAF. Currently, it's a process that is driven by internal people that are sitting with the claims divisions. They would then look at the file, and if they then see that we need to appoint people that can give the version of the RAF, they will trigger the process. The process is still the same. We're using your VRS system, meaning the vendor rotation system. It then picks particular experts in a particular fashion, depending on who you are looking for, if we are looking for an orthopedic surgeon or neurosurgeon or an OT. So whenever we have a panel, all those experts would be in the panel. And how it also works is that we try to have them across the country so that then they can be accessible in terms of where the claimants are. So there would be, obviously there's a request for people to respond, and then you are hoping that they'll respond across the country to make sure that you have enough experts in terms of your exposure in the country. But for now, it's done internally, and not like in the past.
No, thank you very much, and I want to thank you for your earlier explanation. It did bring me into the picture. I do have some questions of clarity, but I just want to make sure the members, Honorable Mende.
Thanks, Chair. Quite interesting. And I have a question in my head, because the issue of the legal experts, internally you dealt with it in a much more proper way, wherein the version of outsourcing was stopped and you insourced the process, which helps because it then answers the question of, then what about the lawyers that were being assisted in terms of being hired by panel, whatnot? Then everyone has an opportunity now to apply and still be employed and get full benefits and all of that. Now, another question comes back that in the medical aspects, because all provinces have got provincial hospitals and national hospitals, isn't there a process maybe that will help us to do the similar insourcing in those hospitals and capacitate those hospitals with doctors that every time we refer the clients or victims from RAF, they are then attended to at those provincial or national hospital. All over the country, all provinces do have those, and then there is capacity there, because issue of medical is a very sensitive matter that must be dealt with proper machinery, equipment, expertise, and all of that. Then a hospital becomes a good place than to refer to a private that we don't want. So I just want to check if isn't there thinking around that, so that we insource even that and then not have a break of looking for outsourcing. Then again, you are accused of there are certain doctors that get appointed frequently. There are certain doctors that are sidelined. There are certain doctors that don't even make it to the panel, which you pick the VRS, yes. There are doctors that apply to be in the database, but they never make it to the database. They have been in the database, but they have never received jobs. But there are people that are frequently getting it. However, if you can apply the same method you are applying to legal aspects, it would work out better, and we won't have any noise around your system. Thank you, Chair.
Thank you very much. Honorable Nilmay.
No, thank you, Chair. Chair, coming back to the medical experts, or those that the RAF have sort of accredited, how do you ensure that these medical assessments are independent and impartial, given that the fund is both the instructing and paying party? Furthermore, many of these medical experts are trained and accredited by RAF. As you mentioned earlier, you have accredited, they know what it is, according to your criteria. So what safeguards are in place to ensure that these experts are in the best interest of truth and fairness? So where the RAF is effectively both the player and the referee. Has the RAF considered introducing an independent or jointly appointed panel of medical experts to ensure fairness and restore public trust in the assessment process? Thank you.
Honorable Nilmay, let me ask you a question of clarity. When you say jointly with whom?
Chair, what we're saying is that, what I was basically saying is that the RAF have got a panel. No, I wouldn't say a panel, but you have medical accredited doctors in the whole country, okay? They are paid by yourself, and therefore what actually makes it fair, in the sense that obviously because they are part of being paid by yourselves. So that is where I was basically saying is, should they not be looking at an independent medical panel so that they don't become the referee and the player? Because of the challenges that you've had in all the reports that we've seen, where claims have not gone through, those were the basic questions that I was actually saying, are you the referee and the player?
No, Honorable Nilmay, I got that first part. Your question was in two parts. So I get that you are saying if an expert is being paid by the RAF, that's what I understand you to be saying.
Yes.
You are suggesting that they might find it necessary to support the RAF's argument. And then maybe what I should ask you to do, if you can, just tell me how the process of consideration basically the instruction, and how the feedback or the report from the expert is entertained, because I think that is the anxiety that Honorable Neil May has, which is I might be incentivized to always say there's no case here. So that's one. But you used a term, Honorable Neil May, which is jointly appointed. So it's jointly, it means it's the Road Accident Fund and someone else. I was asking you, who would they co-appoint with, so that they can answer your question?
No, Chair. I didn't mean that there would be somebody else. So
meant
that would have
independent.
been, I withdraw if I had said that. It was the RF's direct thing.
Okay, no, thank you so much. Can you please just comment on that?
And I'm going to ask Mr. Chako to come in, but I want to start. You see, to quantify an RAF claim, you need a medical expert. And the question that is being asked to the RAF, whether the medical experts that we appoint would be independent, should be a similar question that should be asked to plaintiffs, because they would also appoint medical experts that then will benefit from being paid. So if there's an assertion that there could be some due influence on particular medical experts, so our understanding is that people sign an oath and they must be independent. So when we send somebody to them, so they're independent of the RAF, they are in the panel of the RAF but independent, and therefore they must assess somebody in their professional capacity and provide a report of what they've seen as doctors. Because equally, same medical experts in some cases would do similar work for the plaintiff attorneys, and they get paid there as well. But I want Mr. Chaka to probably add if he has something else to add.
Thank you, Chair. Mr. Mwasias has basically said most of it, but I must emphasize that the medical experts are in essence, in a matter that will go into litigation, witnesses of the court. And being members of the panel of the RAF doesn't necessarily mean that they lose their independence. These are people who has taken an oath in a sense that whatever assessment that they're doing, it will be an impartial assessment that will be done thoroughly after examining the claimant and their reports. Remember, these reports are reports that can be put into court, and the medical expert, as a witness, can be brought to court and examined or questioned about the report that would have given to the Road Accident Fund. So there's no possibility of a medical expert siding with the RAF because the RAF has basically gave the medical expert some job to do. So the independence remain with them. They become ultimately witnesses of the court, not necessarily people who are coming there to represent the RAF.
No, thank you very much. I actually understood it in the same way. But thanks for asking the question, so we can ventilate the matter, Mr. Chaka. I get it. So I'm just going to ask a couple of dumb questions just to understand what you meant earlier. So you said previously the medical experts were secured by your panel of attorneys. So basically you would give the attorney a file, and the file would then the attorney would need to gather such information as necessary to defend the claim, right? So if a neurologist is needed, they secure one and make sure that on behalf of the RAF there is a second opinion, so that you can go to court and fight the case, right? Am I correct? I'm just asking that for clarification.
Thanks, Chair. Yes, that's what it used to happen. But Chair, I want to clarify this one part, that when they procure this expert, they still use the experts that are within the RAF panel. It's not like they will go and find other experts of their own. So RAF has got a panel of experts, as and when that, then they will make a recommendation to say that on this file, after assessing it, we think that as a panel of attorneys, we think that you need to appoint these experts. After they've given us that recommendation, we'll assess it internally, and then once we agree, we'll give them the authorization for them to proceed and do the appointment. So the appointment is done in terms of the facilitation, rather than to say that they will go and source other experts that are not within RAF panel.
Okay, so basically throughout, so the Road Accident Fund still has a panel of attorneys, but it's corporate attorneys now, right, for its own other litigation. So there is a panel of attorneys and there is a panel of experts. When Mkwali Incorporated, acting on behalf of the Road Accident Fund, needs an expert, they will go into the Road Accident Fund's panel of experts in Kuruman and find a neurologist. Hopefully there is one there. Find a neurologist in Uppington or wherever, and then that person then is taken for assessment and the attorney uses that information. This is very important because I didn't want to misunderstand. So what kind of got interrupted with the panel of attorneys being done away with and the experts? That's why I was asking this question. I just wanted to be sure I'm not misunderstanding when you were explaining earlier on. So there was a time when you said the panel is being renewed, it's expired, etc. Just explain that bit here.
Is the panel of experts, Chair? Yeah. That the contract has come to an end, so we have gone to market to then get the same, not same experts, but similar services from various experts. So there was a process that was taken out so that people can respond, medical experts, so that they can be in the new panel of experts of the RAF. So I was just saying that the previous contract ended, and we are still in the process to then get a new panel of medical experts.
Who do you use now?
Now there's nothing, Chair. So it lapsed, I think, I don't know, is it last month? On the 16th of June.
This year?
Yes.
So what do people, even you guys, by the way, I mean you guys actually, so what do you guys do when you now need to defend a matter?
So before the panel, rather the contract expired, there were cases that were identified where we need to appoint because they are critical. But of course, it's a risk that we need to deal with. We need to find a way to make sure that this process of the appointment of panel is finalized. So, Chair, what would have happened is that when there was a need to approve this process by the previous board, the board that was removed by the minister, the board then required a probity report. They wanted assurance from internal audit that the processes to evaluate, and I think Honorable Mente spoke about whether people will complain, why am I not in the panel? It's the standard thing that happens in the RAF, that when somebody was not in the panel, they would then complain on how did I not get appointed. So the then board had asked for a probity report, an audit report to be done on the SCM process for assurance processes. And when that report was due to be submitted to them so that they can then deal with the approval of the process, or rather when the audit team was still busy, I think the board was removed, Chair. And I think that explains some of the challenges that had to happen. And then for a while there was no board, an interim board has been appointed. Of course, when the new interim board comes, they've got their questions on the process as well, because they would have to make that decision. And therefore the current board has to satisfy themselves that before they make a call, because it's a board decision, they would have to look into what process took place, and they would have to make sure that everything else was above board before they approve. At least that's my understanding of the issues now.
All right. No, thank you. We'll ask for a timeline, and this is why it's important. So one of the submissions we have received around the panel of experts is that the panel has expired on several occasions, right? And you've been on month to month before. I mean, there's chapter and verse of it, right? There was a time, I cannot off the top of my head, and maybe the team can help me. There was a time, so a couple of things happened. One, absent of the panel that you were using, people ended up needing to actually travel a really long distance to go and access. So somebody from Lady Brand has to come past Bloom to Joburg for a medical examination, right? So that was one. The second thing is, and it's a specific thing, that somebody was informed, an expert was informed that they are on the panel. They didn't get the contract until like a month before it actually, the panel's time expired anyway. It's a specific thing, right? With names and the like, right? Where someone is on the panel and they just never utilized. and then they get sent a contract which is expiring in a month's time. So that would be the second one. The third one is that there are issues with the payment of your own experts, not the experts of the plaintiffs, your own experts, where their own claims prescribe because they haven't been paid for 3 years, right? They haven't been paid for 3 years. The claim prescribes. In other instances, and the committee members will see the submission, your colleagues at the Road Accident Fund are sending an invoice to pay one of these experts, and the expert is like, you've paid me already for this. I'm following up on other invoices, not these ones, and the RAF has no idea what they're talking about. So are you aware of any challenges in that way? And I'm asking this in general terms because I'm also being careful not to ask you to dabble in matters that may not have first-hand knowledge of. But these are some of the things when we invited public submissions, that people made submissions, including correspondence between themselves and the Road Accident Fund with dates and correspondence and copies of contracts and that kind of thing, to say, I was informed on this date that I'm on the panel, I didn't receive any work, and then they asked me to sign this, but it was expiring soon. So, okay, whatever. That's why I was asking, when did this panel expire? Because it appears to have happened several times before. To the extent that, like I'm saying, people really needed to travel long distances just to be examined because your panel that was there wasn't there. And that's why I was asking what broke at some point.
Chair, I'll speak to what at least I'm aware of. I think I've dealt with the current contract. That's what I can speak about, that it was going in front of a particular board and the board was removed. The current board is applying its mind on what process was followed in terms of recommending the current panel. And I must acknowledge, Chair, that I'm well aware of the fact that most of the experts that would have been appointed by the previous panel of attorneys, not most, actually, that's the wrong word to use, but there are experts that have complained. They've complained to the board as well that they've not been paid, and they would have done work dating back some years. I think, if my memory serves me well, they were talking about 2018 because they had written a submission to the board chairperson, or rather a complaint to the board chairperson around their non-payment. And I've spoken about this thing, that the board chair has given a directive that these things must be looked at so that the reasons for non-payment can be established, so that then the board can make a decision. Look, you find that in some cases when you do a quick check, there's a potential that these experts would have done work where the RAF would have said that instructions were not given for them to be on that work. I'm just saying some of the issues that were there, but again, the chair of the board has insisted that each case must be looked at so that each case can have a reason of non-payment, or each case can be checked if that payment was done and maybe the expert is not aware, or if there's a legitimate claim from a medical expert that was not paid, that needs to be dealt with. And that process to audit that those payment is underway as directed by the board chairperson.
Okay, look, we'll have to ask for this information specifically, right? Yeah, okay. Honorable Skosan?
Yeah, no, thanks, Chair. Just on the previous slide, number 4, where it says the system randomly allocates the matter to a service provider from the database. Now, how do we ensure a fair allocation of work to different experts if we are saying the system randomly? Because the system can allocate that. If we say randomly, it means there are no checks and balances to ensure rotational and fair allocation. It means it can appoint Skosana every time for 5 years or for 3 years. And if other experts complain, we'll will tell them that no, but that's the system. It's just do it randomly. There's nobody who's interfering with the system. So I'm just worried about the randomly versus the equitable and fair allocation of work to all experts that are in the panel.
You can see Honorable Skosara doesn't play the lotto. He doesn't do the lotto.
No.
You mean the quick pick?
No, thank you for that. The system, when it allocates those matters, when we say random, it is on a round robin, so each person would have fair allocation of work. So it does take place on the vendor rotation system. So that is why when you check the number of matters that had been presented to the various medical experts, there is an equal amount allocated to them. And then just to answer Honourable Mente, part of the model of the Road Accident Fund is to insource medical experts within all the regions. It had started a few years back when medical management, the department formed. They've already appointed some experts at our head office, which is situated in Centurion, but there is in the model room for growth to all of the regions where they insource medical experts. Thank you.
All right. Oh, please, Mr. Mkabel.
Thank you, Chair. Chair, allow me to introduce a slightly different dimension to our conversation here. It's not just about appointing the medical experts. I think in response to one of the questions raised by the members here, it's about fairness. In other words, how do we as the RAF advance the claimant justice? From a geographic perspective. So going forward, part of the thinking is to say, how do we make sure that Umakumalo into Zuma doesn't have to travel 300 kilometers to see the expert? And that's a point that my colleague Lance is touching on. We have to go to where our claimants are. We picked up, as I've indicated earlier on, as part of our backlog campaign, etc., where some of the claimants are struggling to have those reports done because they have to spend money to travel. So that's why I'm saying there's that part that as well is so important for us, whilst we are also talking about this in general. So the geographic location is just as important to make sure that we reach out to those claimants who would ordinarily would struggle to be assisted. Thanks, Chair.
No, thank you very much. I think that's absolutely the right thing to do because, I mean, depending on the level of injuries that other people might have, just getting someone from point A to point B, if you're going to travel 300-400 km, it's actually strenuous on the person to do. So the more they're able to go somewhere closer to get the entire package done, the better in terms of just being sufficiently caring as a public institution. That's why I kept asking about those facilities in hospitals and that kind of thing, and the number of people available at the call center. That's where I was going with those questions, because access, you know, here in Gauteng, to go from one end of the province to the other is like a district in the Eastern Cape. It's not even the whole Eastern Cape. So the distances are shorter here. The concentration of experts is higher, but in other places you really actually sometimes just don't even have somebody to go to. So I really appreciate what you are what you are trying to explain here. Just so I'm assuming that inside you do have people that work for you who can look, so they are themselves medical experts, who can look at the report and say, yeah, but this person has done a shoddy job here, send it back. So you do have people who do quality control internally on your external experts, right? And they then assist the attorneys as they do that work, right?
So okay. We do have medical teams internal, Chair.
All right. How does that work? So do you in Monty have some people, you know, so how are the teams kind of, are they all up here in Pretoria, or you provincialize them? How does it work?
Okay, fine.
Okay, so what happens is, Chair, each region has a medical management department. They will oversee certain procedures in terms of the claim life cycle. There is a medical advisory committee which is based at our head office. So where there is a dispute in the region, it would be sent to the advisory committee, who then has some sort of say in making a determination when there is a dispute.
Right. Thank you very much. Honourable members, I'm satisfied with the orientation here for me. I don't know if anyone has got any more questions on the medical experts field, because we're gonna do the system and then the IT system, and then we conclude this portion. But Honourable Madlala and Honourable Skosana, you've got questions, and Honourable Mend.
Thank you, Chair. Maybe I was a bit, sometimes I get, I'm a bit slow. Not a slow learner, but I need to understand there's this issue around the medical beneficiation, or the beneficiation from medical claims, which seems to be largely skewed towards the big companies that are dealing with medical issues. And I think that question was posed, but I just need a clearer answer in terms of the equitable distribution of beneficiation through your own systems, as well as maybe what is in terms of your own empowerment plans as RAF to ensure that smaller firms or smaller, companies, black-owned to be specific, are able to have a share in that beneficiation. And we're speaking about the geographic spread. Obviously, the big companies would have more capacity to spread as wide as possible. But what then is embedded in your contracting? I mean, I know in other areas, we would say that whilst you are in a part of the panel, part of your responsibilities is to ensure that you uplift, smaller companies, so that we can be able to ensure that this development and transformation that we broadly speak about actually takes place, and we avoid monopolies of certain industries, which we understand that the capitalist world will generally, would not just participate voluntarily in. They would seek to monopolize if it was possible. They would want to be the only ones doing that, so that they can determine the pricing and maximize profits out of these entities. I just need the clarity in terms of that. Thank you.
Thank you. Honourable Skosan?
Yes, Chair. No, mine is a quick one. I just wanted to check the duration of a panel of experts. Is it 3 years or 5 years? And I think the Chair indicated earlier that you at some point you were doing month to month because the term of office of the duration had expired of the previous panel. What were the reasons for that? Why were you not able to immediately, when the panel when the term of office of the panel expired, appoint another one? Because I think you should have preempted that on this particular month the duration is coming to an end, and then start with the processes of advertisements and all those procurement processes. Thanks.
Thank you. Honourable Mende, am I correct? Your hand was up. Yeah, please.
No, thank you, Chair. Mine is also linked to what Skosana was asking in terms of the people responsible for doing these renewals and ensuring that all contracts are in place at all times to avoid extensions and all of that. But secondly is, since you are now existing in the far-flung areas to the people, how do you make sure that those victims reach the areas? Is it incumbent on them to transport themselves, accommodate themselves, and all of that, or do you provide some sense of compensation or what? And then secondly, Chair, I'm not sure. Have we dealt with the hospitals? Because I see now we're going to Part B, which talks about other things, the hospitals and ambulances. I just want to check, have we dealt with that? Because I need clarifications.
No. So the hospitals and ambulances.
Because there is a reason why I'm asking that, is that the last time we were there, in particular the Pretoria office, in the office which deals with paying hospitals, we discovered that the bill of private hospitals is too high. And there was a question then, which it is prompted to anyone's mind, that who determines this pricing? I get to this private hospital, one, who pays the ambulance? Who says which ambulance can pick me up from the accident scene? And two, what is the price of a government ambulance that picked me up and the private ambulance that picked me up? There was a difference. Then secondly, I get to private hospital, I've broken a leg. The private hospital sends you 100,000 bill. But I go to Baragwanath, I don't incur so much for fixing my leg. And what are the dynamics there? Who then determines the prices? Why do we allow this gap between private and public? But then lastly, when these invoices come and being processed, who makes sure that there is due diligence before they are paid? Because also a number of the matter here is on those bills that were never paid. But when you look at them, even myself, why is the hospital billing RAF when I pay medical aid? I pay medical aid, I go to a private hospital, and then when I get to the private hospital, my medical aid is paying, but the very same hospital sends the bill to RAF. Please take us through what happens. Thanks.
Thank you very much. So I'm going to provide you with some information, and then you can then tell us, I'm going to ask you a question. So the old contract of medical experts ended on the 31st of January 2020. The new contract from December 2021 ended in June 2025. I'm understanding that that's the one that you're referring to. So there appears to have been a period of 2 years when you did not have a panel. I don't know who deals with that, but the old contract of medical experts ended on the 31st of January 2020. The new contract, the one that ended in June 2025, began on December 2021. So the reason this is important is that it speaks to a number of issues which we will traverse as a committee, and that is the reason the RAF fails in its litigation. Even in instances, I'll tell you there's a real case to the point of the importance of defending matters where this person who was said to be mentally impaired was doing fantastic at TVET college, passing and so on. And the judge looks at this and he says, you should be able to defend this thing. And I don't have countervailing facts to say. So, the judge can't argue the case on behalf of the RAF, but this is a nonsense claim. It shouldn't prevail, but the person gets awarded the thing, right? And this is an instance where your medical expert should have been able to say, this person came in walking here. No wheelchair, nothing, and they looked bright and bushy-tailed. You know what I mean? This is why this is important, because we've also examined a sample of cases, default judgments, where, notwithstanding what you're saying about the attorneys, the stories are frankly ridiculous. right, about the state attorney's office where the person is there, the RAF has applied for a rescission. You know what a rescission is, right? So there's already been a judgment. You're asking it to be set aside. Your state attorney person, I can pull it up. Your state attorney person says, I will abide. The judge says, abide by what? You are supposed to start arguing the matter. What are you talking about? We are here because you asked us to convene here and overturn this matter. Now you will abide. What then happens in that instance? Of course, the judge awards punitive costs against the road accident fund, right, on an attorney and client scale. So the reason we're asking all of these things and we're looking into financial matters is I know you're telling a straight line story. The reality is that when you dig into the cases, you see failures of the system right across. And when I said earlier, we're really looking at systemic problems. I mean, in another instance, the state attorney said to the question that Honorable Atkinson was asking, said, I'm arguing another matter in the same court. I can't be at two courts at the same time. So then there's a default judgment that side. So what I want to ask you to beg you to do is that you're not in trouble. We are trying to identify what's going wrong. It's not necessary to sugarcoat things. You know what I mean? If you don't have enough state attorneys, colleagues, please say so. Say we would love to have 600. We only have 200 at the moment. We are constrained by X, Y, Z. That's what you are here to do. We're not unreasonable people. That's why I'm introducing these things, not to catch you out, right? But I can pull up judgments where it's laughable what happens in the courts out there. You see, and then the intervention around the 180-day issue, it's this thing of the RAF being at 6s and 7s. Part of the reason there is this thing that you must argue one thing is that the judges got sick and tired of an attorney saying, I'm supposed to appear in courtroom B also, same time. So that matter goes unargued. And the courts award punitive costs around at the Road Accident Fund for failure to appear. And we've asked the Road Accident Fund for this information. It's the principal claim, it's interest accumulated, it's basically the cost of counsel for rescission judgments, then it's punitive costs, it's writ costs, it's sheriff costs. You know this happens. Ne? Please be candid with us. Where there are capacity issues, tell us. We are here to try and solve that problem. Everything sounds hunky-dory and it's not. No, it does, because you guys tell a straight line. It's all... It works, you understand, and you are not helping us help you as an institution when you don't tell us where the resources shortcomings are. Because Parliament's job, if we need to change the law, ask the minister to do something to help you, then we can ask the minister to do so. You understand? So we're not here to blame you. But please give us perspective on these matters, because I'm now looking at these judgments and I'm like, those state attorneys are actually a mess. And you guys know it. There are not enough of them. There are not enough of them. If you disagree, please let me know. There are not enough of them. The reason there is now this whole process with Judge Sutherland is to try and solve that very problem. You guys don't have enough people to defend the matters. You are overwhelmed with cases. Isn't that so? Yes. So please be candid with us. Then we can help you.
So, Chair, I think let me deal with your last comment. So, when I said that state attorneys are appearing in court, I was not addressing a capacity issue, but I was addressing a principle whether they are appointing counsels to go to court on their behalf. So, at the point you asked that question, I was just saying that they themselves go there and argue, as opposed to appointing counsel. So, I was not addressing whether they are properly capacitated. I must just say that. And I think Mr. Mkabela dealt with it, and it's probably sitting in one of the submissions of the RAF to say that there's a need to capacitate that space. And I think Mr. Mkabela Eila spoke about it. So I'm not going to differ with you on the issue of scaling up the resources in that function. And of course, we need to look at scaling up the claims environment as well. It's something that is an open conversation with the board. It's an open conversation with EXCO, that we need to look into our claims environment and properly capacitate it. And also then we need to look into our state attorney environment and properly capacitate it. And I'm not going to beat around the bush about that, Chair. And I think I will not differ with you about that. That we need to look at claims, capacitate claims so that we can, reach as much as we can reach. We need to capacitate the state attorneys that we have so that they are able to do what they need to do. I think what I was dealing with earlier was that they are capable to go to court and argue matters. That was the issue I wanted to address, Chair.
All right, no further comments. Is it just me who's feeling hot here? It's like the aircon is off. Somebody's gonna faint. Can we, Lost guys, can we just see if we can ask someone, yo, I'm about to die. And we darkies don't feel warm for like, usually we're feeling cold. Yeah, please. Okay, but thank you very much. So anyway, the general ask is that, you're not here to blame us. We regard this as some kind of orientation. If there are capacity issues, also just say that part of the challenge, especially when I was asking around the numbers, not trying to catch you out. If there is a capacity issue somewhere, just say it and say, look, to tackle this kind of number, I need X number of people. I don't have them. So I'm not lazy. You're not being defensive, you're stating a fact. You know what I mean? I'm not being lazy. I need 300 people, I've got 120. Maybe if I had 80 more, I could make a big dent on this thing. We note it down when Honorable Hlengwa comes here. Now we can have the conversation with, and the board comes here, because you're not the board, right? How do you look at the budget of the road accident fund? Why are you not helping these guys? Why are you spending money on that as opposed to that one? So they can help people. That's how this process, I'm not upset with you. I'm just saying, don't worry that we will use this against you. We're also doing this to assist as well. Okay, so please. Okay. Does anybody want a quick break? Because people look finished here. So it's 5 past. Can we come back at 15:15, please? Just, yeah, fresh air. Yo. In your computer and you activate. Thank you so much.
Okay. Hopefully I don't, maybe as a starting point, before I get into the actual slide that's been presented, let me paint a bit of a picture in terms of where we come from for us to get to this timeline and where we're at. So prior this timeline that's been presented, a couple of iterations were done from a systems perspective in the fund, where an attempt was, one, to get an integrated solution that will provide a holistic view of claims, payments, reporting, and a view of the claimant in different forms and different facets. Then obviously those iterations, resulted in the guys going out to a benchmarking exercise, which then, that benchmarking exercise highlighted a couple of things. One was that worldwide there is, I think, 3 solutions that are primed to be, capable to be bought and used from an RAF.
Sorry, can I interrupt you? So, sure. The thing is being streamed. So the people outside say your mic was.
Okay. I'm going to try and keep still. Okay, where was I? So I was saying from a benchmarking exercise, I think we had 3 solutions that came up. The two were then obviously discarded solely because of they were pure insurance based in their nature. Then what then I think was critical for us to understand from a fund perspective was that a solution that will actually fit the fund would need to be one, a solution that has a number of components, a solution that actually gives the fund the ability to also then configure, as in change, the processing or the processes within that solution. And this is what then eventually, from a specification perspective, the fund went out with to say, okay, 2021, we issued a bid. This bid went out into the market where we were looking for a solution, one that will obviously administer, claims throughout the value chain as critical component. Secondly, provide an environment that will be conducive to integrations with other systems. I mean, if you have listened to the colleagues present so far, everything that we do touches with other areas, within the ecosystem. And we wanted to make sure that that solution that is or bought or sourced at that point in time has the capability to actually grow and morph with whatever regulatory dispensation that may exist at the fund at that point in time. Then bids were received. Upon reception of those bids, we then we awarded PwC. Then the award to PwC then brought the current solution that we're using, which then meant that the product that was proposed is a product that we'll look at. Secondly, they would then also, be part and parcel of the implementation partner that we go to. Signed the contracts in 2022, I think. What does my timeline say? 2022 contracts were signed. Then from that point, late 2022, we then kicked off the project. So the principle or the ethos around it was that the solution that was proposed by PwC was an off-the-shelf product that allows you to actually build your business processes based on a number of permutations, depending on the capability that you are sourcing from that product perspective. Once we kicked off, we then started doing, then also as part of the proposal, we then decided to do this thing in two releases. Release one, which was to say we want to put down a minimum sensible product. So this is a product that will enable us capture a claim, assess that claim, ensure that that claim from a workflow perspective is channeled to the right assessing parties within the organization, drive that claim through to the adjudication process, and eventually get that claim to it being, being able to be paid. That would be the first release, scope, which was delivered. I think we went live on that 2024 September. Go live of that release one product. We also then unpacked it a little bit more, said, let's take in terms of that go live, it would be risky for the fund to go big bang. We then went live in two of the regions. within the fund, which was the inland regions. That go live then was meant to do two things for us. One, introduce a solution to the organization. It's a new product. It's a new way of working. And it also introduces tighter controls. Therefore, the expectation from the project side was that, one, we are going to get a whole myriad of issues that will come out because of those channel of things. I mean, new product, new ways of working, and lastly, the introduction of those tighter controls. That product then went live. From that perspective, we then brought in the coastal regions, I think the following year, which was 2020.
Sorry, if you can pause.
Okay.
I just want to ask the members, are you following? Because I don't want us to... and the reason I'm asking is that I'm getting a little bit lost in the terminology, so I might need you to start simplifying things. I just want to ask the members if I'm alone in that problem. I am not alone. Eh? Okay. You're an IT person.
Okay,
Eh? I'm not an IT person.
Let me slow it down.
You're an
Yes.
IT person. Yeah. You're an IT person. Okay, let us just... so, I mean, just explain, what is this system supposed to do?
Okay.
Basically, is it supposed to... It's the one place where you go, if you... I think you called it a link number. I'm just going to use my layman's understanding, right? You can change what I'm saying to explain it better. Basically, if I were to pick up the phone and ask someone at the Road Accident Fund with my Mkaya from East London here, that, listen, where is this claim, right? You can go onto this thing, type, and then say, okay, no, this matter is now sitting with our internal medical expert. There is a medical report from outside. We have not yet made a decision on it, but in due course, there should be an answer. And the next step is either we will settle the claim or it will go to court and you'll hear from your attorney, whatever the case is. I'm just trying to kind of put it in simple language to say all of these different pieces, is money going to be paid? Is it paid? Is it with the lawyers? Is it in court? Somebody's supposed to just type into this thing and then see a lot of information about the case and give. Is that what it's supposed to do?
Yeah, that is exactly.
That is in essence. So you then needed to get a system that then responds to the environment of the Road Accident Fund, the lawyer issues, the medical issues, the appeals in court and that kind of thing, as well as pulling out all the reports if the board wanted to get a view of how are we doing on that project to reduce whatever, and you can give all those lovely graphs.
Yeah.
Is that what it's supposed to do?
Yes, that's what it's supposed to do.
Okay. No, I don't want to assume, but I can tell you're an IT person.
I think maybe to easily explain it, Chair, Lance, maybe go to the next slide, and then we'll come back to this timeline slide. Yeah. Okay. So the ethos of the project was, if you look at the items that we were faced with as an organization, one, I think one honorable mentor mentioned that you guys visited the offices and you found boxes and boxes of things piled all over the place. This solution is meant to, one, eradicate that, because everything that we do as part of the solution, we digitize, as in the paper file that we're currently using in the fund, that is, one that's transported across the different areas while it's being processed, is now digital. That's number one. So therefore eradicating those boxes and boxes that you would find, providing a central repository that one would actually go in and look for information and then find it there. Number one. Number two, if you look at the legacy system that we were using, one, it was old from a technology perspective. Two, from the design in terms of how the actual system that produces the link numbers that you're talking to was designed. The technology was out of date. And secondly, that solution was designed as separate systems, which then somehow never gave that full view that I spoke to earlier on of a claim, a claimant, and the relationships associated with all of that. Then I think lastly, you touched a little bit on it to say we needed something that will provide us with better insights from a reporting perspective, something that will make sure that we, when we need to slice and dice, we are able to then attack the data in different areas. And that's the basic principle that we were going after in developing or in going for this for this solution. What does it give us? It gives us a single source where you type in a link number, even though now we don't call it a link number in the new system. We call it a claim identifier. We put in that claim identifier.
Hey, I was thinking there's a fancier term, like, I don't know.
We're still on the lookout for the fancy term.
Okay.
You put in that claim identifier, then you get a dashboard. This dashboard then gives you everything at a glance from a summary perspective about that claim. It then, the intuitiveness of it also drives you as to how then, you then get to go through actually getting to understand the picture of what that claim talks to. I think lastly is obviously, as I said, automation of the other things. But I think from a business perspective, one of the things that we wanted to look at, you touched a little bit on the costs that we get from, legal fees and all of those things. One of the things that was critical in terms of making sure that being able to provide that information would then enable the fund to be able at any point in time. So for instance, if you look at what we did from an implementation perspective, we made this solution available to the call center and said to the guys, train them to actually have the same view that a consultant sitting at a pre-assessment or merits or any of the value chain business processes actually gets to see. So everybody sees the same information at the same time. So if you call and you want to inquire about, you should be able to receive the same kind of information that you would get from a person that either we would have called a claims handler at the time or the call center agent that might be answering your call. Does the process work 100%? Debatable. It's a new solution, and like any other of implementation, you're going to have teething problems. But I think, in having said that, what I think I also want to bring to the attention of the chair and the committee, as I said, that the project or process is being run twofold. We did a release one. That release one put down this minimum sensible product. And this is the product, the fund that is using currently, right? So we are currently busy with release 2. So release 2 is going to take this release 1 product and mature it. By maturing it, it means I'm bringing in integrations. So far we've brought in integrations to Home Affairs. We've brought in integration to the banking systems in terms of verifying, all the bank accounts that we actually eventually pay at the end of the payment process. We've brought in integration to Inatus in terms of also looking at the vehicle information, how the consumption of that vehicle information relates to things like hit and runs, where if you do have a registration number, you are then able to, draw back to who the vehicle belongs to from a system perspective. So we looking at bringing in things like compensation fund, UIF, all those touch points, so that the ecosystem from an RAF perspective will be complete. Obviously, baby steps. I mean, these things are not going to happen.
Yes.
Yeah. But that's the plan. The plan is to make sure that this thing matures, and it's matured to a level that it creates, I think you asked what's this ICMS? Yes. An integrated claims management system that the fund is able to utilize across all the areas of the business and provide a single source of the information that exists at the fund at that point in time. Now,
can I ask? So, can you just give us a sense of? I've got this question, right? So earlier on we had a conversation about how is the claim submitted, right? I genuinely thought you can do a drop-down menu somewhere and attach and click submit, right? And then your system does your thing. And you guys said no, the legislation says you must walk in. And so what happens now with this? Because this seems to me the logic I get, right? But now you've got this thing right at the beginning where the law says walk in with a file.
Yeah.
Can you help us there? Because
go to the next slide, Lance.
Oh, is it the next one? Okay. Yeah. Oh, sorry. Then the other thing I wanted, just give us a color, honestly, just like a story, because when I saw that in the previous slide, where you're saying, for instance, it's supposed to help you with fraud, and we spoke about Inatus, maybe somebody might give a registration number and say it was a bus, but it was a bike, actually. Yeah. And when you look on Inatus, you're like, yeah, but this was a bike and it was deregistered 5 years ago. That kind. So it's to help you with those kind of things when you draw the linkages with other systems. Home Affairs, they say it's a boy, actually it's a girl. That kind of thing. Okay, I get it. All right, you can move on to the next one then with the paper and digital things.
Yeah. So if you look at the solution, the design, we've got 3 products that we've incorporated as part of the solution. Guidewire, the updraft solution, and obviously the reporting part, the data warehousing part of it. So from a Guidewire perspective, you've got different modules that, as you can see on the slide there. We've got Guidewire Claim Center, Guidewire Customer Engage, Vendor Engage, and Guidewire Predictive Analysis. So each of these modules have a different functionality. Claim Center, you just asked now, Chair, to say, if you look at the legislative mandate that we've got now is electronic submission and things like that can't be done. So you need to walk in or either bring us a physical copy. So the Claim Center, Guidewire Claim Center component of the solution gives us that capability. So that one is used internally within the fund, which is predominantly what we have gone live with now, as part of Release 1, to say to the guys, whilst the claimants or attorneys are walking in and you're doing your pre-assessment, then you capture that information in Claim Center. Then Claim Center, consolidates and then puts it, makes it available to everybody nationally within the fund. Customer Engage, Customer Engage is primed to actually do the online and self lodgement capability. But obviously, I think the legitimacy and the drive towards obviously making that available will be dependent on the legislative changes that the DM spoke to in saying we will need to increase those channels, for us to be able to accept a valid claim. But the idea around Customer Engage is to say anyone who has a cell phone, anyone who has a laptop should be able to sit in front of that laptop, interact with the Customer Engage portal, drop in all their documents as required, and your claim will be lodged in that sense. Ready and waiting, but as I said, some things must happen first for that to be used.
So basically now, if somebody submits, brings in a claim, so somebody literally then has to take that information and put it into the manually?
For now, yes.
For now?
For now.
Jeez, okay. I mean, I would have thought that that's one thing Parliament needs to kind of sort out rather quick, seriously.
Yeah.
Because it potentially, it just creates a redundancy out of something that could be great, you know what I mean, and improve access for a lot of people who,
Yeah. For now, I mean, Chair, that is what obviously the solution does. But I think from a capability perspective, there's a whole lot more that one could do from an automation with the product that we've got. It's just, I suppose, an issue of one, access, and also internal, I think, items. And why I say internal, I mean, you should understand, I think maybe what I should share is that if you look at the perception that existed within the organization with the introduction of this was one, it was always seen or primed to be one of those things that one will be responsible for job losses, because with automation you bring in certain elements where things can now be done seamlessly by solutions. So we really needed to be careful how much automation is then brought in. And also in looking at the maturity of the organization, are we ready to transform, from a tech perspective, the organization to be a smart working organization? So those are the considerations we had to make.
So you are now, are you doing this in stages? So it says GuideWire plus Updraft plus, right?
Yeah.
Are you doing them in step, or are you doing them simultaneously? Simultaneously, okay, all right.
Right, so the Updraft part of the solution is what we use in our, as you see, legal claims resolution platform. So what that does for us is it has provided us with the capability of being able to, one, quantify the liability, that a claim would go through. So the colleague spoke a little bit earlier about the assessment and of merits, and tying that quantification of merits to actual case law, so that when we do give you, be it a merits offer or a quantum offer at the end, that offer comes with case law that backs it from a rationale perspective. That's what the Updraft solution does for us. And as I said, the last one, the IDP solution, which is the digital platform, actually creates or provides us with the capability of being able to slice and dice the data that is inherent in the solution. So all of them together forms the ICMS. Integrated in that they work together to be able to then, let the claim be traversed across the value chain when we go through the process. Okay, should I continue? It looked like
Honorable Beasley, no, we are bamboozled here. Honorable Beasley and Honorable Neil May.
Thank you, Chair. So just with my financial thing, is it linked to the financial system? Is it integrated? So there's a direct linkage between the system and the financial system. And then secondly, what happens to those 75,000 claims that aren't valid in terms of, do they make it onto the system?
Okay.
Thank you.
I'll respond to that.
Okay, and then mine is, where is it stored on the cloud? In which country? And what security mechanisms have you installed against cyber attacks?
Storage. That's it. Okay. Yeah.
You are doing very well.
I think two questions. I think your question was two parts. First part is 72,000. So as the colleagues have already, you'll see there's already a classification in terms of compliant and non-compliant claims. So what we do is we take in the non-compliant claims as well. What we take in there, though, is minimum information. Because, we're not going to look at processing that any further because of that compliance state. Then all that will go through is the compliant ones, where we will then, process even more when we go through it. Linkage with the financial system, critical. Very critical, because one of the things, this is, you'll see the next slide. I think it's one of the questions that you asked, to say, you would want to understand the old versus the new, and how those differences would work. Okay, so from an integration perspective, yes, it is linked to SAP right now, which is our current, financial system within the fund. And the linkage is so tightly coupled that from a control perspective, what we have done is just made sure that the controls that have been built there actually require minimal human intervention, solely because we wanted to safeguard, those financial transactions that actually end up in the SAP system. And then ensure that the correct also transactions find themselves in that financial system. And that integration touch point is one of the first that we wanted to make sure was right. The colleagues will tell you that at some point we had a bit of a challenge in actually paying the claims that we had taken in, and it was because one of those controls was not functioning as it should, and it was critical that any transaction we had to fix that before we can actually let anything pass through. Storage. So everything that you see in is all contained in the cloud. Data residing obviously within our borders. That was one of the first things that we needed to do. And we then also, you'll know with any tech, things can happen. We've tried to split this thing from a redundancy perspective, that it actually traverses 3 cloud environments that we have in the country. So, it sits within the Microsoft environment, AWS environment, and Oracle environments, which are the big 3, cloud. So at any point in time, anyone drops, the other one picks up. That's the type of redundancy that we've built onto the solution. And then also, because, if you, I'm not so sure the committee, but I'm sure with the kind of complaints you get in the media, as I said, that our systems, internally were old. I mean, half the time you'd go to the fund, then they'll say the system's offline, or we just wanted to get rid of that kind of stuff as well. So here we can ramp up and ramp down as required, depending on what the requirement is at that point in time. So if the volumes are heavy and higher and we need more, we just bulk it up.
Can I just ask before we go on any further? So the information on the non-compliant. So in fact, let me just ask a process question. So there are the claims that are still not finalized in terms of your annual. I think there's over 400,000. They've still not been. What's the category? So there are these claims that have not yet been paid. I'm just looking for what they call total outstanding claims, and the bookmark here says claims where compensation has or has not been paid, but payment for legal costs outstanding. Mm-hmm. Right? So that's the category. So claims where compensation has or has not been paid, but payments for legal costs outstanding. So that suggests to me that a claim might have both where it has not been paid and there are legal costs outstanding, or the claim itself has been paid but legal costs are pending. Right? That's what it means to me. So I'm just now talking in terms of project implementation process. I'm assuming then that your first job was to take the existing data and make sure that it's accurately stored in the system, right? Mm-hmm. So that you can produce a category. So is the system able to, so in other words, when this data that we get here in the annual report in Parliament, is it produced off the new system, or is it still on the legacy system?
Combination.
It's a combination.
Yes.
Okay. We can talk about modalities later, but it's a combination right now. So the second thing, I need to understand your rules around the storage of the data where the claim has been deemed non-compliant. How much of that data do you actually store?
Okay.
Out of that file that you get, how much is stored?
Okay. So for now, what we capture of the non-compliant claims is everything that is in the RAF 1 form, barring the documents that come with that submission, because those documents then will just be taking up space. I mean, if you look at the compliancy, because where we have pegged it, we have said, should it meet all the criteria that is required as per, that submission, then only then do we take in the documentation. Just as a management, space management from a solution perspective.
Okay, so thank you. So the reason I'm asking this is that this new procedure is under litigation. And at some point soon, the courts will pronounce on it.
Yes.
I just now want to know, does this mean you know exactly who's been rejected for non-compliance? So in other words, you know who they are, you know where they are, you know who their attorney was, or whatever the case, so you've got that information. What you appear to be saying to me is that you don't have the attachments by way of medical reports and the like, and that at that point you will ask those same people to go and find that information.
Yes.
And resubmit it.
Chair. That is exactly what I'm saying to you, Chair.
Have you had a discussion internally about the treatment of this as a project risk and a financial risk down the line? You understand where I'm coming from, right? Because someone has to say, because you are baking in a certain sort of taxonomy in what you kind of store and what is not going to be available, right? First of all, and secondly, and this is an issue that is pending. I just want to know, have you had a discussion? Was it legal advice that you were given that said, proceed as if the matter is settled, or provide the infrastructure for the, just in case, for the purposes of, if we have to reactivate these things, we can then just reactivate the data on the system. In other words, if they'd grayed out because there's no need for someone to access those attachments, you are now able to make them live. Because what that says to me operationally, it kicks off another massive project that the Road Accident Fund has to have additional capacity for in the event of the conclusion of that litigation. You get where I'm going, right? So did you have that conversation? Was there legal advice taken or given?
Look, from a project perspective, no, Chair. There was no legal advice that was sought. However, the guidance I think the project got from the STEERCO was that, look, while the legal matters are pending, we need to continue as business as usual. So we need to continue. You asked a question earlier, Chair, where you said the RAF one, in relation to the solution. So meaning which one? The one that is being, questioned now or undergoing legal observation. And yes, Jay, we are using that RAF one form as the basis of the solution. But I think, from a foresight perspective, we sort of understood that the landscape that the fund operates in, we need to build these capabilities in such a way that the solution is agile enough to say, when we are told to say, now you have to change and revert. Changing the solution to pivot to a different direction should be easy. That's number one. Number two, the actual data storage pertaining or storage that relates to the touch points that you want to have, as in your base, set of information. You have access to that. Then it also doesn't, then require you to start from point zero to now capture and then move the process along the value chain. I think those were the principles that we use to guide how we configure and develop the solution.
No, I get that, and thank you. So, firstly, who sits on the STEERCO for this? Not names, just roles.
Yeah, STEERCO would be all of the EXCO, as in executive management of the fund. People from obviously the vendor, PwC, and project team.
Okay, so I'm just going to ask the Secretariat to note that. Was there a legal person in the STEERCO, do you know?
Legal person in the STEERCO, yeah, that would be CGO. From the person heading legal.
No, it doesn't matter. I mean, legal, somebody from a legal department. I don't know how it works. Here's the concern. The concern is this, that you are building a system that is being built on legal eggshells. You appreciate that. Because the assumptions built in its design might be collapsed by litigation, right? which means the data that has been submitted to you that is not being stored later on becomes relevant.
Okay.
And so instead of 400,000 claims not finalized, you're looking at 700,000. That's what will happen, right? Because the RAF has lost that case, right? So that's a concern. It's not a question. That's why I'm asking who sits on the steer co, because then when we ask about, because there's project risks, the project risks are numerous, as you would know. It's all manner of things, but there are legal risks within that risk analysis. And it would appear on the face of it that that seems to have not been considered at all. And that actually the potential final cost of the project may be higher than anticipated, because you simply have to go back and do the things that you had been told you don't need to do. You understand?
I'm with you, Chair.
I'm also going to ask another question, therefore. Can you describe the nature of the financial linkages between the system and SAP? You use SAP for your finance part of your ERP, right?
Yes.
Right. So the information here, and let me explain why so that you all know. That there was an effort for debt restructuring at the Road Accident Fund, right? The submission, one of the submissions we've got, and it's not something you have to, I'm just now being transparent with you in terms of why this aspect that I'm asking is particularly important. That's what we will hear from, I think, week after next or late next week, right? Is that the measurement of the liabilities, right, depends significantly on the number of claims that you recognize as valid. So when the information is captured on the system here, when this pings SEP on the other side, it triggers an accounting event, which is to say, we potentially could have to pay this claim. The problem with this from an accounting perspective is that these claims that are sitting on eggshells, on legal eggshells, because the litigation is ongoing, are being treated from an accounting perspective as claims that don't exist. But they do. And the court tomorrow, depending on when a judge returns a judgment, might instruct that the Road Accident Fund needs to recognize all of those. And in terms of the graph that was shown earlier, they number over 100,000, closer to 200,000 in number, right? 170 something odd thousand, I think the number is, or thereabouts. So that is part of what we as the committee are looking at. I know it's nerdy stuff, but it's really important, and I'm hoping that you get it, right? And so your understanding of the scope of the project is narrow, and the reason I'm asking who sat on the steer co is that the allegation and the submission is they deliberately told you to do this in order to prevent that accounting event from occurring. You're not on the steer co. That is what will come out in testimony here.
Okay.
Right? And it's therefore got a, so that is why I'm asking you, when this information is put in here, how do those interfaces work? I need to understand in terms of the rules, when does it get made a sort of a potential liability? And for ease of reference, if a company, say Transnet, gets sued for 2 billion, the chief financial officer of the finance team has to make a provision of 2 billion as something that you potentially could have to pay. It's accounting practice, isn't that so, Alan? It is, right? As something that you potentially need to pay. If you win the case, that thing comes out of the liability side of the balance sheet, but you've made a provision for it. what this system is doing is pretending those events don't exist. That's a system that you're building. So I now am asking, in respect of those that you do recognize, what event, what sort of a digital record, financial record does it create on the other side? Are you saying to me that once it's now been recognized, right, and you've got an idea of how much could be at stake in this claim, what does this system tell SEP on the other side? Do you know that? I mean, if you don't know, you don't know. But if you do, please let me know.
No, I don't, Chair. But what I can say is that liability is only quantified once a claim has passed a certain stage, within the value chain. So meaning a claim has gone past merits and it's at adjudication stage. Only then, does the solution create an estimate, which this estimate is what you're actually going to use as that liability.
Right. So can you just go back, please? And I know we're going to be jumping. Please go back up because I need you to just illustrate this here. This is super critical for our process in the longer term. Just keep going up to the claims thing, not your section, the previous section.
Claims, yeah.
Claims, yeah. Go up once more. Go up once more. Go up once more. Go up one more time. Go up one more time. One more time. One more. Okay. On this here, right, when you were taking us through all of this here, so there is receive a claim, register a claim, verify and validate a claim, establish merits. That is where you start seeing that red, right? Establish merits. What you are telling the committee is that it's only once it gets there that there is some quantification, therefore, of how much money could be, and I mean in general terms, right? So basically, you need to have all of that information that tells you whether there is a claim for general damages and that kind of thing. I am expecting, so if I recall well, the testimony in the morning was that in terms of how, maybe that's how it worked before. So you would do the settlement progressively. In other words, general damages have been established. You can deal with that part and you complete it. Then there is, you progress to loss of future income, medical expenses and so on, which means the accounting events at the time would begin at general damages of $1 million, and then you add 500K because you've now settled, you've kind of concluded the next thing, then you add another 300,000, and then eventually end up at 3 million, but it's a progressing thing, right? That is in terms of how it used to be done, right? The way it is done now is that all information pertaining to all of those aspects needs to be available up front. Yes?
Okay.
Yes.
Chair, we speak about the medical records. Yeah, okay. No, we're in the same page.
Okay, so that you then able to basically have an idea of what you might be dealing with here, okay? That means, and I'm sorry that as a tech person, I'm burdening you with accounting problems, but I need you to understand why I am asking this particular question, and it's so important. That means the accounting event is not actually progressive. It might be progressive, but on a shorter timeline, right? Because the RAF now wants all of that information from the onset, the possibility of quantifying the number is greater actually now than it was before, the total number, because you've got everything that you need from the get-go. And when you were mentioning case law and that table that says a finger is 3,000 rand, little finger 500, etc., all of that, right? The system analyzes all of that. It should kick out a number theoretically, right? Some number. Because you also know in these cases where someone has broken a thigh or both thighs, the payout typically is for somebody with a professional qualification. I'm assuming that would be part of the analysis that the system is potentially able to do. That means your ability to give a potential financial liability is greater under the new system than it used to be. That's what should be, right? And this is why, and this is for the members, this is why this part of our conversation is so important, because the system, so there are two things that become important. One is that the system is being built and set out in a way that you might need to undo or amend later on, because you would have to, right? All that information that has been, so that when it pings the accounting on the other side, it actually gives it the full data. What we are hearing is that that data that would tell SEP that the liability should be X amount is kept out of the system entirely. That's what it means in practice. So, and it's not your problem. But this is why I asked you colleagues to come here and tell us about this stuff, because it does speak to various aspects. I get the logic of, doing it. I think you should get all the money you need to do it and do it so that people don't need to go to all of this trouble to walking into an office. But the way the system is being built now has this risk built into it. We will ask management when they come, right, why it is that you were given an instruction in this way. But I just wanted to get a sense of how it then interfaces. Okay. Where is the project now in terms of project completion? Are you like 50% there, 60, 70?
I would say we're about 70%.
Oh, cool. Okay. Just in terms of your current assumptions,
Yeah,
right? Until you are told otherwise, that's where it is. Okay. Just help us with the payment system.
Yes. Okay. So in terms of the payment systems, from a process perspective, we haven't really changed much. All we have done there, as I said earlier on, Chair, was remove, the paper-based aspect of how the payment process was being rather ran through the organization. That's number one. Number two, built in a lot more controls in terms of how the actual process also drives through. So meaning approvals. Those approvals based on obviously the existing delegation of authority policy are now tightly coupled, which then gives a whole lot more control on who approves what, when, and how those approvals, based on that delegation of authority, then pushes the transaction across. But in terms of the segregation of duties at a process level, the payment is still similar. I mean, the processes still run the same as they did old and new, because there's been no refinement that was required in the current dispensation, of refining that payment process.
Thank you, Honorable Beasley.
Thanks, Chair. So we have heard that there's duplicate payments. Is that a system problem or a people's problem?
A little bit both. A little bit both in the old dispensation. Because of as I said, the desperate system, individualized compartment lines, you sometimes would get two vendors with the same name, but because you haven't checked how the two vendors link.
So the reason you look at me and not him, and you're not disrespecting him, it's this damn mic. You always have to be close to the mic, so he won't feel offended if you're not looking at him. Just look at the chair so that.
Okay, Chair. Okay, Chair, noted. But yeah, I think in the old dispensation, you would be able to get that. New system, cleaner. What we've done there is each vendor and how that vendor links to their banking information. Hence the integration with the banking, verification systems, just to make sure that that one-to-one relation is always maintained. So those duplicate payments going forward should not exist. Should not exist. If they do, then we've got other problems that we probably will need to look at.
Thank you. So I've just got a simple question around this duplicate payments story, because it makes the papers. Is it because some rogue attorney or service provider out there submits the same invoice twice, or submits a fake duplicate invoice, or there was something in the system? I'm just trying to understand what actually went wrong, because it's not really been explained. In other words, why wouldn't the system pick up that Honorable Atkinson has already been paid? And I know whichever system it was, I'm hearing you to say it's a legacy system, it's not this new one, right? Technically, what was the flaw there? What was the issue? Assuming either way, was there fraud where an attorney would sit there and decide, let me try and rob these guys and submit this thing again? Or was there some technical event that would happen, or fault? What was it?
Here I'll have to lean to my other colleagues, Chair. But I think maybe before I pass on to the colleagues, systematically, even in the legacy, the colleagues would be able to identify it, I think, through a process of analysis. But it just took long. That's number one. Number two, the potential of also happening because of the systems not being integrated was high. The disparity that you've got, the payment system, from the offer system being two separate items, then the passing of information between the two would result in such items. But I think from a business process perspective, my colleagues would be better suited to respond to that.
Thanks, Chair. I think the issue of duplicate payment, Chair, it happened when attorneys, they attach the bank account of RAF. You'll find that we will process a claim up until we make an offer, or either there's a court order, we request that payment, and then because it's still waiting for it to be paid, some attorneys will not want to wait for them to be paid. That was before even the issue of the 180 days application was done. So instead of them waiting for up until RAF does the payment, they will go in and attach RAF's bank account, meaning that they will submit a rate, and then the bank will have no option but to pay the amount. Whilst the same amount is already requested on the system, maybe they will attach it today, the following day, then the payment will go through. Now, I think the main issue was in terms of the reconciliation from the bank attachment vis-a-vis the amount that would have been processed internally. So that's how that process of the duplicate payment happened. I think SIU has been, I think, investigating this matter and dealing with it, I think, when it comes to those payments. Thanks.
No, thanks very much. That's helpful. And I'm hoping that one of you knows how to. So I'm assuming that. So let's say today there is basically the court says the road accident fund should pay. The road accident fund intends to pay the money. It's just not paying it yet, right? And then eventually the same claimant and their attorney approach the court to say the road accident fund is not paying me. I now want to attach their bank account. And the court agrees, right? A stupid question. When that the claimant seeks that order, is the road accident fund notified, and are they able to defend the application? They're notified so that they can defend. Is it like a thing that just happens without the road accident fund knowing? How would it work? Do you know? Sorry, just switch off the mic. If there's like lots of them going, then the sound just doesn't capture.
So, Chair, it will be a writ. It will be a writ that will be issued by the sheriff, and of course the sheriffs would notify the RAF that the writ has been issued. And where there's a need for it to be defended, it's when probably there's a particular issue that makes the road accident fund have an issue to pay that claim. And of course, then you might have to get an attorney to deal with it. And I think in my understanding that the attachment of bank accounts also happens very quick. That when a writ of attachment of a bank account happens, the attachment to the bank account was a quick process, as opposed to other writs where a sheriff will notify and say to you, on a particular day, I might remove your furniture or do an auction. And then either we launch an application to deal with that writ or decide to see if this thing needs to be paid. But the bank attachment writs would naturally happen faster. But the sheriffs do notify the RAF that there is a bank attachment writ that has been issued against the RAF.
All right, thanks very much. So I think one of the things we need to, and a lot of claims get made, right? And we do need to get to the bottom of things. So there are a couple of things. The amount of time that elapses between the judgment and you guys intending to pay the thing and the attachment of the bank account is a significant amount of time. I don't think the courts spuriously allow bank accounts to be attached. I worked for a bank and I've seen a few of these things, right? It's not easy. It really isn't, right? It's easier to reserve an amount of money in an account. In other words, the account gets basically, it's easier to get that amount of money to be ring fenced than it is to, it's the next step that you are talking about, right? So there's a process that goes on there. But by the time you get to that point, the court appears to agree that this should have been paid a long time ago. And the only option that's left is either for somebody to come and fetch your furniture and that kind of thing and sell them, or basically to do this option over here. That's the one thing. The second thing is, it appears to me that system-wise there was a breakdown where someone is supposed to say, we've received this from the sheriff or from the court, they're going to attach the bank account, therefore we now need to record that this needs to happen, so that if we're going to pay this tomorrow or next week, we don't, or we tell the court, whichever way, that we are going to pay the thing by a certain date, and therefore, that's why I'm asking these questions about whether the RAF is able to defend the matter or not. So in the system, when the writ is issued, is there someone who records that data in the system so that the payment is not made or some other intervention is made?
And I think at least my minimum answer to that question is that the rates for bank attachments happen very quick. When it comes to normal rates of execution, where probably there's potential financial removal, I think because those processes take time, that kind of interaction happens. But the time lapse between and I would not know because I don't have the data with me on the speed in which a RIT is issued and a bank is attached. But one of the potential things that most likely would be happening is that somebody removes money today from the bank, and most likely the following day they get paid because they were going to get paid, or even the same day. There is that potential, but I'm saying that I don't have the time lapses between, a RIT served, money removed from the bank, and a payment done by the RAF. I think that study would need to be looked at to deal with the question that you're asking.
No, we'll ask for that information, but generally, we'll ask for a general timeline from the road accident fund and also from the sheriff. But basically, to me, that is a final step after repeated attempts to get the money paid. And what I'm hearing is that even when you intend to pay the money, for some reason it doesn't get paid until the person goes to court and attaches a bank account. And I don't know if you know why that is so. So you intend to pay the money, you don't, until the person goes to court, and the court finds a period of delay so unreasonable that they take the drastic step of agreeing to attach the bank account. Do you understand? I just need to understand what causes that. Is it cash flow issues? What is it?
So, Chair, there's multiple issues. There are, and I'll be blunt because this is a SCOPA hearing. There are issues where payments that the RAF would want to contest, people would use the sheriff and attachment of bank accounts. I think there's court cases out there around issues of foreign claimants that were found to be illegal in the country. There is that portion of the payments, and most of them have writs. Obviously, state attorneys and other legal processes are taking place around those ones, but writs have been served, and sometimes bank attachments have been served on claims of that nature. But
can I interrupt you? So remember, you guys have already told us the RAF intends to pay. That's how the double payment happens. So we passed that stage now. You already have told us you're intending to pay, right? And all that happens is that the claimant has been waiting so long, they've now eventually attached the bank account. But you were intending to pay. What I'm asking is that of those you were intending to pay, what causes the delay?
No, it's fine. I'll focus on those ones. So there's multiple things, and sometimes it's the internal process of the RAF where a court order is served on a particular individual, and there was a delay in terms of process that court order. We've got those instances where people that were dealing with those court orders would have received the court order, and the court order was not processed on time. So those examples exist in the RAF. It's the reality that is there. You've got instances and examples of practitioners that would bring court orders when they're over 180 days with a writ. I think we've got instances where we even engaged a particular judge president to say that this practice that is happening in this particular court where court orders of the RAF are delivered late to the RAF. And Chair, I'll concede there's court orders that get delayed by people that have received them in the RAF. And that is why there was also a view of creating a centralized email so that everybody must send court orders to that particular email. It was the issue of trying to deal with this thing. You have, and Chair must also say that you had a situation where people receive court orders and they're busy with other things, and then they process that court order late. Because when a claim is handled, there's somebody that deals with that claim. And when a court order is issued, the court order then gets sent to that person, and that person then needs to deal with that court order and make sure that it's processed through the system up to the point that it's paid. I must mention that that problem exists. And so various ways to deal with it was to centralize mailboxes, try to find ways to interact with attorneys to communicate when they have not been paid. So there's various efforts to try and deal with issues of making sure that payments that are due are done. I mean, the latest one was done by the board, where they engaged plaintiff attorneys and said to them, if we owe you, please tell us. These are the numbers that you must call. The call center as well was engaged to make sure that we trace court orders that are not paid. So there are a number of issues that create that problem.
So I would then, let me put this question. So it would not be generally true. It would not be generally true to therefore tell Parliament or the public that where double payment is made, it's an incidence of corruption or an attempt to defraud the road accident fund. From what you guys are telling us, the answer is it's complicated.
So, Chair, I think we must just be careful. So where there was submission that there were instances of corruption with double payments, I'm sure the people that would have made that claim would have submitted that kind of an assertion. I'm not speaking to that. I was dealing with your question around
I'm speaking around what you are saying, because one of the things we have asked for, by the way, and we've received the spreadsheet, is all the incidences of corruption vis-a-vis or alleged corruption vis-a-vis certain law firms. We'll deal with that later on, right? The point I'm making is I think we can finally get to the bottom of this thing about double payments. And the story that you are telling us is that there's a variety of reasons why it happens, right? But in generally, it has to do with writs. Generally, it has to do with writs, where the attorney, for whatever reason, and I think that the legislated period for payment is 120 days, right? Is it not? For valid claims. For valid claims, it's 120 days, or is how much is it?
Sorry, so in our offer discharge form, if an attorney accepts an offer, in terms of the offer discharge form, it will be paid within 180 days. However, you do have, in terms
so the 180 days, is it in the RAF Act, or is it the agreement you guys reached with the High Court?
Well, it's an agreement reached with the claimant, and there is case law where we've approached court to determine that time period.
Okay, let me let that go for now, but carry on, yeah.
In terms of the High Court rules, a payment should be made within, I think it is 30 days, and interest will run after day 14. So there is that provision.
So we are therefore dealing with delay. So it's only after that somebody may approach the court for a writ, right? So in other words, the court has decided this amount must be paid. You guys are intending to pay it. After 30 days, the compound interest rate is how much? Starts kicking in, right? Until it reaches an equivalent of the capital amount. So what is the compound interest rate? Do you guys know?
I think it gets determined, Chair. So when
it's determined by the court. It's not that germane. So, but basically, they're all of this. So, following that, right? For some reason, the thing doesn't get effected within 30 days, and I'm assuming that only after that 30 days has elapsed, does the claimant go back to the court and say, I've been waiting for this payment to be done and it's not being, and then they obtain a writ. Two events are happening, which is germane to the work of this committee. You see now that amount is accumulating interest, right? And then your account gets attached, and then eventually you pay it, but now it's a double payment and it has to be unscrambled. That's the picture. Because the interest keeps accumulating. You understand? And that's some of the things we needed to get into. But I think you've sufficiently enlightened us. And on the system, this entire mess that we are now discussing here, it's not something that you can go and press a button and work out where this thing is right now in terms of the court process and whether this thing should be paid or not. Or is that less of a problem now than it was before? It's less of a problem now. Okay, no, thank you very much. Okay, you can just, I think you've kind of enlightened us. I don't know if there's anything that you think on the system is important. You said you're about 70% complete on the system, right? In terms of expenditure, do you look after that as well? Where are you? So there's a project milestones and then there's expenditure. Please show us.
Mike, okay. So what we included here, Chair, is obviously a slide on, okay, I see the bottom part, the totals are, just make it a bit bigger. Yeah, this gives a total view of what has been spent so far on the project.
So look, all we're looking for is the total budget allocation is X amount. We are at Y amount.
Total budget 877. We've spent 5 something.
No, thanks for our purposes, that suffices. Thank you. Okay. Honorable members, do you have any further questions on... Okay.
Okay, Chair, thank you very much. And I've got 2 questions. I just have to find where I park the other question. But the one question I wanted to say to you is that finally the journey started in 2021 in putting your system, the system together. How long would it take for you, should the court rule in another direction, for you to unbundle what has been done and set up a system that is compliant, should I say, compliant? That was the one question. And then, so let me hear that one first, and then I'll give you the second question. Thanks.
Do I respond? Okay.
Yeah, thanks, Chair. I just think the important thing is the figure there. I don't know, it's got so many figures there. It's nearly R1 billion. So essentially, as the Chair says, it's been built around eggshells, and it all could come crumbling down, and R1 billion could be potentially...
No, okay, I'll respond to that. I think let me handle the other one. So what we have, as I said earlier on, what we have done with the solution is, if you look at the environment that the fund operates on, changes, legislation, court, case law, those things are moving targets. We've built this thing in such a way that where there is a legislative mandate that requires a change, those adaptations are easily done. And by easily done, the normal, if one has to put a timeline to it, process that we, would be applicable in a situation like this is 6 to 8 weeks. 6 to 8 weeks, we can morph this from a business process perspective to shape or flow to whichever legislative mandate that we may be required to do.
Thank you, Chair. Chair, that was the answer to the question that I asked you for the time.
Yeah. I'm not sure if you want me to answer Honourable Beasley's question. Okay, let me then. So if you look at the split and the expenditure, a big chunk of the expenditure sits within the actual cost of the products, not the implementation cost as such. So 60% to 70% of the costs there is the actual product costs, license fees, and those kind of things. Those will be there in any case. The implementation, which then will talk to the configurations that talk to addressing the actual environment from a cost perspective overall right now, amount to 30% of that budget. So total cost of the value of the project in relation to what would that, so you're looking at 30% of that value that's sitting there. Should we totally scrap everything that's in the solution right now?
Thank you, Chair. Then coming to, I'm also on the budget utilization. So certain contracts such as SOW4-ICMS, support and maintenance, show 100% of the budget remaining, raising questions about delays or inefficiencies in utilizing allocated funds. Why has 100% of the budget for SOW4-ICMS support and maintenance remained unused, and what are the implications for system maintenance and support?
Okay.
And then I've got one other last question, and then I'll wrap up. Thank you, Chair.
SOW4, let's take, are you going to ask the other question?
Yes, while the system is described as centralized and efficient, there's no data provided on its actual performance metrics, such as resolution times or customer satisfaction rates. Can you provide performance metrics for the query management system, such as an average resolution times, escalation rates, and customer satisfaction scores? Thank you.
Okay, let me start on SOW4. So SOW4, while we were, busy with obviously the implementation process, we then, decided, as obviously via Steerco, that that part of the project we will descope from the current vendor, because the actual costs that they wanted for them to be able to support and look after the solution for us were too high. And therefore, the reason why it has not been used is because we've gone out to market to look for a vendor that will then take over the solution once this implementation partner leaves the actual project when we finish with release 2. So from a safety perspective, because we're doing this in 2 releases, so we're still quite safe for us to be able to, while we're building the maturation part of a release 2 perspective, the project is looking after the solution from a support and maintenance perspective. Then post that is where the challenge will be. But by that time, we would have then appointed this vendor, because the tender is already out, in the market, and we're expecting, obviously, responses to that support and maintenance part of the process. Customer satisfaction, there I have to be quite honest. We haven't done any. But I think I'll let Mr. Mkabela also chip in there, because I think internally we've received some feedback in terms of, but from an overall, project perspective, because we're still in project mode, we haven't really done, that satisfaction survey just to get a sense of how are people using how they're finding the solution and what, efficiencies they would want to see, or rather optimized as part of the process. I mean, we're still developing, so we're still bringing down, putting in capabilities into the solution.
All right, Mr. Mkabel.
Thank you, Chair. I'm just going to cover the customer satisfaction part of it. As part of the presentation that I was going to be making, Chair, we went into details to actually explain the fact that we have implemented a customer relationship management system. This is against the backdrop of the RAF that never invested in technology for decades. It's important to talk about that, Chair, because we are here, amongst others, because of all those issues. What we have done, we have implemented a system to record every interaction that we have with the claimant. We know the average handling time, which is 4 minutes, 38 seconds. We also know the turnaround times in terms of how quickly we can go back to the claimant. We have a fully fledged outbound section of the contact center, whose role is to make sure that we interact with our claimants, we give them the status of their claims, but also, similar to what the banks are doing, we allow the claimants to assess us as a fund to say, how did you experience the interaction with the agent? We do have that data, very detailed data, Chair. In addition, we have multiple channels where we are able to tell at any given day, at any given time, how we are doing with respect to respond to our claimants. So I'm happy to cover that as part of the queries and complaints section. But in the interest of time, I wanted just to make sure that as soon as the ICMS system is completed, and once we have actually logged in the integration with the CRM, which is the front part of the system, you will have a real-time measures of how we're doing. We do have a long list of metrics that we're using to assess ourselves as we speak, which I'm happy to share later on when we get to that point. Thank you, Chair.
No, thank you very much. You know, I am thinking that what we might need to do, honorable members, is that we're going to get to a time when we need to work out what our recommendations are. So my suggestion is that we'll most likely invite certain aspects of what you're going to talk about, because it is important. I think following today's discussion, I have a much better idea, and you've all been extremely helpful. I've got a much better idea of what the total ecosystem out there is like. We've traversed lots of issues. It's been messy, but the reason for me that the conversation about the system is so important, and what your input, and I'd really like us to get that input, was we have to make recommendations around how the entire system should be resourced and improved, because what I'm now picking up is that it's not just the core system, as it were. It's how soon people get paid, how accurate those payments are, and that kind of thing, which then in the end speaks to that customer satisfaction score, because at the end of it, you are able to say to the claimant who's happy, they've now been paid, to say, please rate your service with the road accident fund. If it's whatever, press now. You know how it works, right? So basically the vision that I'm seeing is that you want to create a platform that is able to record information accurately from the get-go, right through the journey to the point where the claimant has now completed, and you can ask them, so how was your experience? What were the issues? Press what, etc., etc. I totally get it. So we will give you a more specific brief that integrates everything, because we'll also ask you to help us with our recommendations at a later stage. So don't stress about, that aspect, because I've learned quite a bit from our interactions today. And so as we make an assessment of all of this, I think we'll be much better informed in terms of, so I might ask you to come and do a presentation to us, so that it then informs our recommendations to Parliament, and then which get transmitted back, and hopefully you guys get more goodies and the public ends up being happier in the end. So I don't know if members, you've got any further questions. I'm happy, honestly. I also really have to thank you for your patience and resilience. It's a long day. I don't know if you guys woke up early, took the 5 o'clock flight. You did? Oh, thank you. No, thank you. I really, Honorable Pila has got a question. Sorry.
Thank you, Chairperson. All the eyes are on me. because the time has gone now. I just want to comment on what has been said now, the issue of the system, because document submission and claims capturing are clearly noted as persistent challenges. So I think the system will be able to help us and fast track the process of paying the claimants. But I have one question here on funeral expense cap, which is at 18,000, if I'm not mistaken. So there is no explanation of whether this cap is sufficient or has been reviewed in light of inflation or claimant needs, because those who are claiming are from a different background. So I just want to check, have you reviewed it recently? And is it aligned with current economic conditions and climate needs, that 18,000? Thank you.
Chair, we are in the process of reviewing it, and our actuaries are looking into that so that it then deals with inflation and so on. That's just a straightforward answer. We're looking at it. And yeah, let me leave it there, Chair.
Actually, those people are so clever. They look like they're looking there while they're looking. But no, colleagues, I really want to thank you. We will most likely call on you again, but be more specific in terms of the help that we want. It might be a written submission. It might be a short presentation to the committee, because we've now got a sense of how the processes work, how some of the decisions are made, the system issues, and so on. And I know sometimes the conversation was a little testy, but I'm certainly better educated about your environment therein. We will review the conversation today. If there are any further questions that we have, further documentation and so on, the Secretariat will get in touch with the board so that you can further assist us. But I also want to say that at the time when we want to start making recommendations, we really actually very possibly will ask you to just come and just tell us what would be the advantage of doing this. If you did XYZ, what would happen, so that we don't make crazy recommendations to Parliament as well that cannot be implemented, right? Because at the end of the day, what we want is a seamless process where, and an accident is a traumatic event. You just want to make that the whole thing as painless as possible. The experience, certainly from the Road Accident Fund perspective, and that also, as you do it, the cost per claim of the Road Accident Fund drops in terms of what it costs to finalize it. You know what I mean? Even if we're not talking about the capital amount, that the cost per claim is a number that we can say, look, it kind of works. So we are going to ask for your help again, so that when we make our recommendations, we can say, if these investments were made, the Road Accident Fund would be able to be this X efficient and save X amount of money, and customer satisfaction would be even greater and that kind of thing, and therefore we're recommending. So we will ask for your help on those kind of things. So I really want to thank you a lot. Can I say before I release them, so we have the Department of Transport here. I can see the members are really tired. I think some of the members are reaching for their bags. The colleagues from the Department of Transport, I think, when is your flight? 8 o'clock. How much? 2025. I would really like to release them by 7, 10 past 7, so that they can make the airport. What we want from them, the ask that we made of them was, we want to understand how the department and the ministry oversee the Road Accident Fund. You favored us with a presentation. It's too long, to be honest with you. I thought you were going to give us 5 slides. You don't have to wait while that happens. So basically, just really what the committee is looking for is just explain to us, this is how we oversee the Road Accident Fund. This is a team that does it. These are the things we look at. This is the frequency of the reporting, etc., etc. And this is how we follow up on things that have happened, etc., etc. We will ask the ministers themselves to account for specific things. Right now, we are looking for just how does it happen, if you can appreciate that. Then you don't need to miss your flights. Can I therefore ask that while they are changing, we just take a quick body break and then we can have that conversation and then we can release you. Thank you. Thank you. Thank you very much. Thank you. Work. And, you know, with the various kinks that happen from time to time, the various issues, how is it that you deal with them? We are not, the members might ask questions in terms of what happens in this or that other case, but basically we're not at the point where we're asking what happened with incident X. That will come later. We just want to understand how things work today. Thank you. Over to you.
Thank you, Chairperson. Good evening, and good evening to the honorable members. My name is Mulatelo Mozepe. I'm the Chief Director responsible for Public Entity Oversight, currently the acting DDG for State-Owned Companies Governance, Assurance and Performance. And I'm with my colleague, Advocate Mahato, who is in the Roads branch. She's also a Chief Director, as well as colleagues in the oversight function, Advocate Ruzano Makale and Mr. Dina Pile. So just an overview of the oversight function that we play at the Department of Transport. So it is in twofold. It resides in the branch, which is SOGAP, Assurance and Performance, as well as in the road branch. The road branch will then look into the policy, the legislation, the regulation that needs to take place. And then the SOGAP, Assurance and Performance, mainly derives its functions from the PFMA. So the PFMA details how the public entity should do the strategic plans and how they should report on a quarterly basis. We also take our directive from the Road Accident Fund that talks about how the board should be appointed and what the functions of the board and the CEOs are and the function of the entity as a whole. We also get our directives from the Treasury regulations that talks about how the quarterly performance should be structured and by when they should be submitted to the executive authority. We also look into the protocol on governance on public entities as well as Companies Act and King Codes. We also take our directives from the performance agreement that is entered into by the minister as executive authority and the accounting authority, which is the board. So in the main, we look into the performance through the quarterly reports that the entity would submit 30 days after the end of the quarter. So when the quarter ends, the entity will go through the process to ensure that there is quality control. Then they will submit to the department in terms of the performance agreement. We will then analyze and suggest corrective measures or actions, especially of areas of concerns as well as corrective measures. And this is the advice that we give to the minister, and the minister will then communicate the analysis of the outcome to the entities for actioning. We also do a performance monitoring on the finance, how the finances, the budgets is going, where there's underspending and overspending, where there's unauthorized expenditures and irregular expenditure, where we also engage with the entities and we ask for corrective measures and explanations. We also do a monitoring on the AG and the action plans, and we are also responsible for board appointment processes, how the board is functioning, looking into the resolution registers to ensure that the decisions that are taken by the board are in alignment with the mandate of the entity. We also look at how the board performs in terms of the agreement that we have with them from a shareholders' company, because there are certain indicators or KPIs that they would need to report to the minister on a quarterly basis. I'll then hand over to Advocate to talk about the legislative oversight that they do over RAF.
Thanks, Chairperson, and good evening to honorable members. Just to add one point, the department has a departmental rep that sits on the RAF board, and this person is appointed by the department as such, or the DG. Further to that, Chairperson and honorable members, based on the needs and their implementation of legislation as it sits, department, we would take the lead insofar as determination of policy and legislation is concerned. Now, RAF as the implementers of legislation that would have passed, they would highlight areas where they might have been found wanting, be it from a court decision or constitutional court decision, as the case may be. And for that reason, we would, in collaboration with them, one, put it out for comments, assess it, and do the necessary due diligence. And from there, having worked on it, check whether it aligns with what we have in terms of our policy. I can use the example of the RAPS bill, which the DM alluded to earlier on. Honorable members, the RAPS bill was put out as a policy, and the department, in collaboration with RAF, has taken it through the approval processes up to a point where Cabinet endorsed it. Emanating from that was the development of the Road Accident Benefit Scheme bill. So that's the kind of work that we do within the roads branch in the department. Thank you, Chairperson.
So that wraps the overview of our oversight work, Chairperson. Thank you.
All right, thank you. So I'll just give the members an opportunity to ask questions. I have one or two. Honorable Atkinson.
Thank you very much, Chairperson. The one issue that obviously came up, and I mentioned with the Road Accident Fund, is the fact that the fund itself is a creature of statute, and it's very, 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 very clearly delineated in the Act as to how the fund must conduct its business and what the requirements are for putting through a valid claim. And we do know that the initial requirement was, there were 3 requirements to have a valid claim registered. We do know that there was another board notice that was issued by the fund requiring a whole lot of other things, effectively pushing out a lot of claims that actually were, in terms of the Act, legal and in essence should have been considered. Nowhere in the Road Accident Fund Act does it give the board of RAF the right to change the legislation. That can only be done by Parliament. Okay. So, as the overseeing body of the Road Accident Fund, I would like to know what your position was on this, on the fact that effectively the law has been contravened by the fact that the very basis of the operation of the Road Accident Fund has not been legally compliant with the Act, and the result of that is the creation of an unquantifiable liability for the state at the moment, which could be considered to be the largest unquantifiable liability that there is at the moment, possibly even bigger than ESCOM. And that all that flows from the fact that the Road Accident Fund has been allowed to operate effectively not within the bounds of the law. So I would just like to know how that came to happen and how your department effectively missed that. Thanks.
Thank you, Honorable Matlala.
Thank you, Chair, and thank you to the delegation. I want to understand the quarterly reports. Now, if you can break them down or just take us through what are these reports that you get through which you hold the RAF accountable? For example, do you get an internal audit report? Do you get an operations report? Or what is the structure of those reports? And the question is premised on seeking an understanding of what information comes through to you. And this information comes on a quarterly basis, so you could be 3 months backward in terms of what is happening. So you only learn about what is happening in a RAF on a 3 months interval. And I also need to understand what is your processing mechanism then of the information. So you receive a report, and then who processes the report? I know that the feedback then will be through a letter or through a meeting with RAF and so forth and so on. And I'm asking this because the challenges of RAF have been going on for many years. And the recent decision to disband the board also premises on some of the issues that have been happening over a period of time. So how effective, what I want to understand is how effective is your response mechanism to a detected potential crisis or potential risk area at RAF as a body that is given the responsibility to provide oversight. Thank you.
Thank you. Honorable members, are there any questions from your perspective? Honorable Neil May.
No, thank you very much. One of the shareholder representation on the board. So the Department of Transport has a representative on the board, serving on the board. And from 2020 to 2023, the name was given who was the shareholder representative. And from 2024-25, there was no shareholder representative at the board level after the former gentleman resigned from the department. Around June, somebody was appointed to the board. How much information does your representative bring back to the department, and what kind of intervention do you see this representative? Because as we have seen, there have been many unlawful decisions made at the board. And what kind of interaction, what kind of intervention can one immediately expect with the representation on the board, so that one doesn't again go into this many years of a different financial package, financial system, instead of GRAP, there's the other system. So how are you able to intervene with your representative on the board? Thank you.
Thank you very much. Honorable Beasley.
Thank you, Chair. So just following up from Honorable Atkinson is the fight that the RAF has had with the Auditor General. I mean, surely as the department, you have to say, no, this is not right. I mean, and who's ultimately responsible? Is it the board? Is it the minister? Is it the department per se? And then in one of the slides you mentioned there about directors' delinquency, I think I'm pronouncing it word. Would you consider this bearing in mind the shambolic affairs at the RAF, and whose decision is ultimately to make that call? Is it the department? Is it the minister? So who actually makes that call? Thank you.
Thank you very much. I'll hand over to you, colleagues.
Yeah, maybe. Thanks, Chairperson. So let me start with the question posed by Honorable Atkinson. Honorable members and Chairperson, RAF exists as a juristic person. And you look at Section 15, they can sue, they're entitled to take any action or defend. Now, there are certain submissions that have been made earlier on regarding the RAF 1 form. And that is that it has been challenged quite a number of times successfully. You can cite the Mautla, I'm being long-winded, but I'll get to the point. You can cite the Mautla, the LPC, and so forth. Now, the position with regard to that was that we've had, in fact, differences of opinion with regard to that, because a form by its nature, right, forms part and parcel of the regulations, Honorable Atkinson. And for that reason, it's the minister that is empowered to issue regulations. The form would constitute that. And then for that reason, right, there was a process that was followed. Eventually, the court found that the RAF form itself is unlawful and void. Hence, as it is now, what the department is doing is they would file a notice to abide, and when the needs arise, explain departmental position insofar as this is concerned. And as correctly stated or alluded to by our colleagues from the RAF, the matter is serving before the SCA, and RAF are appealing that decision. Again, the department has filed a notice to abide, given the fact that it's unlikely that there would be any prospects of success on that point. Thank you. Well, the rest, they are more governance related. I would leave them to the acting DDG. Thank you, Chairperson.
Let me first to respond to the one on the shareholder representatives. So yes, it is correct that for a year we did not have a representative sitting in the shareholder in the board, and it was mainly due to the fact that we had capacity challenges, and also we could not find a suitable person to go and represent the department, because we're looking at the challenges that RAF was facing at the time. And one of the issues was around the accounting state standard. And we needed to take someone who was skilled in accounting, who understands, until we eventually found someone who was then ultimately appointed in June. So in terms of the intervention, is that the shareholder rep is basically a representative of the DG in terms of the Act. On a quarterly basis, and as and when necessary, the person reports to the DG for intervention or urgent intervention, where the DG will then make a recommendation to the minister to act upon the recommendation that the shareholder representative is also making. There also is a challenge from a legal point of view, because the shareholder rep really doesn't really have a voting right. He's just there to ensure that the interest of the shareholder is protected at all time, and to ensure that everybody is aligned in terms of what the marching orders or the mandate of the department in certain areas is, just to emphasize on that. Then there was an issue about if it's the responsibility of the minister of the department to declare a director delinquent. I think there is a process that my colleagues can outline, but ultimately there has to be a process, and there has to be evidence found that indeed that the director did not act in the best interest of the company, and there were fiduciary duties that have been breached. And there will be a process. There's an SIU investigation that is happening and ongoing, and the minister will act based on the recommendation that would come. If there's been found that there's financial misconduct and so forth, then there has to be a process to follow. And it's also stated in the performance agreement in terms of what the minister must act when board members do not comply, especially with PFMA. There was an issue on the quarterly reports, the effectiveness and the risk. Do we detect the risk that are there? So in terms of the treasury regulations and the reporting framework, the entity has to go through internal control, where internal audit will verify the performance information that they are reporting to the department, and must be signed off by the board. When it comes to the department, what we are mainly interested in, outside of other issues, is the performance based on the APP. and the AOP. What did you say you were going to do in this quarter? Why did you not achieve it? What were the challenges? And also we look at the risk that the entity is facing and decide how are we going to mitigate those risks that the entity is facing. So at times when we make corrective, when we make suggestions in terms of corrective action that the entity needs to address, we would then have to follow up. We would put on our matrix, these are the things that we are following up on entity, and then we would have meetings and continuous engagement to see how are they addressing those kind of challenges that have been outlined in the quarterly basis, in the quarterly monitoring reports. How effective it is, I think there's an acknowledgement that our oversight model has not been as effective, and currently the minister and the department are working on restructuring on how do we then bring in the kind of skills and expertise that are required based on what is happening. And it's not just on RAF. The entities that are currently in a financial crisis, the entities that are not performing. On the APP, it says they're performing, but we don't see the impact on the ground or on the community of the people that we serve. So we are trying to do an oversight model that can have an impact. That can have corrective and urgent corrective measures. Because you are correct that we get report 30 days after the quarter has ended, and some of the issues have been overpassed by events, so it's a bit too late, but that's what the PFMA dictates, how the entities should report.
So, sorry, can I ask, so I think part of Honorable Madlala's question had been, so what are the different sections in the quarterly reporting? What do they report on? I think that's where you were going. So what is contained in the report?
Okay, thank you for that clarity. So we basically look at the operational performance as per the APP. We look at the financial performance, how the entities are doing. And one of the other things we were also monitoring is the legal costs, because we were also concerned as the Department of Transport on the high legal costs, and how we're just monitoring how are they doing and the reduction and mitigation that they're putting in place. We also look at the corporate governance structures, and as well as key executive position, especially the CEO, the CFO, and audit. So we look at all that, internal controls as well. And so yeah, those are the three sections that our report would then cover. Sorry, there was an issue about the AG, what have we been doing? I think there are many correspondence that we did share with SCOPA, where letters were written to the RAF, where the minister was emphasizing and urging the board to desist from this legal action with the AG. And the minister has mainly two rules, and this she has shared and said everywhere, that AG is right. What was the second one? The AG, never argue with the AG is always right. So that is our standing point as the department.
So and I'll come to you, and I just want to be certain. So we're not just asking about this minister. So when we, so basically, I think I like your answer to cover the ministry. Let me put it like that, the ministry, which means if there's one minister involved, you cover them as well.
Chairperson, I can only recall of one letter that I have or the department has. We couldn't find evidence of the previous minister, Minister Chikunga, but in 2022, the former minister, Minister Fikile Mbalula, did write to the RAF about the tabling of the annual report, and also cautioning the board to also stop the legal proceeding with the AG. So he did caution in his letter. He did say that although he could not dictate on what they should do, but he cautioned them that they should consider stopping this legal action.
All right. So I just want to check because I saw the correspondence in the file. Was that finished to the members? Is it on the shared drive? Okay. Can we make sure the members have got? Because I know that you sent. And the only question I wanted to ask with regards to the correspondence, because when we'll call people to account for their things. I saw there were lots of letters from Minister Chrissy and Deputy Minister Hlengo. I would say that was 90% of it. There was one letter from former Minister Mbalula. There was 0 from former Minister from Minister Chikunga. Was there one? Yes. And so the only question I've got to ask is, how long have each of you been at the post? How many ministers back are we talking? The reason for my question is this. Is it because these letters don't exist? In other words, there was no oversight? Or is it because they chose other method of communication? Because there's a lot of correspondence from Minister Chrissy about various things, but they only one letter each from the 2 ministers. And Minister Chrissy only started last year, so I just want to understand. But let's take the questions together. Honorable Neil May and then Honorable Beasley.
Thank you, Chair. And it's a follow-on on the comments that you've just made because of the Department of Transport's oversight role and accountability mechanism. In 3.3.2 of the presentation, criminal liability in terms of Section 86 of the PFMA. The Section 86.2 of the PFMA states that the board may be guilty of an offence and liable on conviction to a fine or imprisonment for a maximum of 5 years if there is a willful or grossly negligent breach of the fiduciary, general and financial duties. The board has been doing that for quite some time. And if you look back, there seems to have been no action because the accounting standards right from the beginning, when the board agreed to that accounting standards, which was not in line with the PFMA, why has it taken so long, do you think? Because under Section 86 of the PFMA, that board, the previous board, is guilty of an offence and liable on conviction to a fine and imprisonment. It's clear that they have not complied in their oversight role, the board, with the terms of the PFMA. And hence my question was, there are representatives on the boards here, there are quarterly reports, but this problem child has been there for quite some time, yet nothing has happened with regards to until now. So I would like some comment on that. Thanks.
Chair, you covered me. Thanks.
All right. Thank you very much. Can you... Honorable Isak.
Thank you, Chair. I'll be brief. Chair, I was going to speak in the opening remarks regarding, the discussions with National Treasury, the quarterly reports, the fruitless, wasteful expenditure, irregular, etc., that you oversee. But I think that's been covered. Honourable Matlala also got into it. Then I must just ask, because obviously there has been in the press lately a mention of the introduction or regarding the road accident benefit scheme, a new bill that you might, which was discarded, was tabled in Parliament 2-3 years ago. I'm sure you're aware of it. The intention was maybe to then reintroduce this bill. Then what must emanate from that is, how would, if that discussion has been taking place with the minister, etc., how would then this be financed, or how would you handle financing a RAF and this bill And then, of course, the question arises to that is if NHI eventually comes into effect, then what is then the circumstance around that, if you've captured my question clearly? Chair, thank you.
Thank you very much. Over to you, colleagues.
Thank you once again, Chairperson, and thanks to Honorable Isaac. So, indeed, there has been reports that we need to process the Road Accident Benefit Scheme, the RAPS for short. So, now, Chairperson, we need to look at what is it that the RAPS bill seeks to address. And as it is, RAF operates in a very litigious environment. Now, why? The issue of fault, right? And what does that do? It brings about other stakeholders within the space, right? And RAP's bill seeks to say we proceed on a no-fault basis, defined with defined benefits, amongst others, right? And what we've done as well is we've embarked on an environmental scan given the period that has lapsed between the rejection of the bill itself and where we are now, the advent of NHI, the impact of that on the RAPS bill. So those are engagements that are being pursued, and as alluded to earlier on, Chairperson, we are now getting to a point where we would want Cabinet to grant us the approval to put it out for public comments. Insofar as the financial implications thereof, I would want to inform members, honorable members, that when we started the process of the RAPS bill and its introduction, we've had engagements with National Treasury. And as a key stakeholder, we would need to go back and look at the numbers that were crunched at that time based on the report and the modeling that was done. Bring it to a point where we are now, that what would be the cost implications moving forward in us now trying to introduce the RAPS bill. So we still need to crunch numbers on that. Yeah. So I cannot, at the top of my head, some sort of figure, Chairperson, that this is how much it would cost now, because it's something that we need to work towards.
No, thank you. No, that's fine.
Okay. Thank you, Chairperson. Maybe just to deal with the question asked by Honorable May regarding the financial misconduct. Of course, Honorable May, you are very much correct that in terms of the PFMA, the misconduct from Section 50 to Section 55, it constitutes financial misconduct. But what is very much important, and what you must note, is that when you read subsection section 83, sub 4, it tells you what must happen. It says financial misconduct is a ground for dismissal or suspension. So in this case, we all understand that one of the grounds which the minister decided to dissolve the board, it was the issue of failing of the board to execute its fiduciary duties in terms of Section 50 of the PFMA, which also clearly stated in the letters of dissolution which were sent to the board members. So that is the reason why the board was dissolved. So from where I'm sitting, I think the first part, it was implemented. The difficulty with regard to Section 86 of the PFMA for conviction and all of that, for me, I think it's the vehicle. We have seen this it has failed. If you remember well, the late Dudumien, that case just disappeared because I think the question is the instrument. How are you going to, who is going to open that case and all of that? So, I mean, for me, I think it's still a challenge from where I'm sitting. And I'm not saying this cannot happen, but I'm just saying, but at least we have to congratulate the minister that she has done something in terms of section 83, subsection 4. Well, maybe just to move on and to deal with the question asked by Honorable Beasley with regard to who has the locus standi to bring the application of what we call a delinquency director in terms of section 162 of the Companies Act. Well, the Act stipulates various parties who can bring the application. It can be the shareholder, prescribed officer, company secretariat, registered trade unions. So says various of parties who can bring the application to court. You know, of course, you have to prove the issue of gross negligence, breach of fiduciary duties. I don't know if I'm doing justice as I pose, Chairperson. Thank you.
Thanks, Chairperson. There was also a question or comment from yourself regarding why did it take so long for the department to communicate its dissatisfaction regarding the AG?
No. More specifically, no, actually, that's not my question. My question was, there are only 2 letters, one each, from Minister Mbalula and Minister Chikunga. I'm trying to get an insight into why that is. Would they opt for meetings instead, or is it indicative of the level of oversight? Because you guys looked for correspondence from ministers during the period under review. All we could get from before Minister Chris's time were 2 letters. And I'm assuming that there was an exhaustive search for those letters and you could only come up with 1 each. So I'm asking, did they prefer another method of communicating other than what is written? That's why I asked you when, how long you've been there.
Chairperson, I think that will be a very difficult answer to give. I would not know why there were no...
Is it because you were not there? Or
I was there in a different role. I've been the chief director for over a year now.
Okay, yes. So you were not there, so you wouldn't know.
I was there in a different function, but I wouldn't know what would have been their preferred method or why they did not communicate. In fact, I wasn't even aware that Minister Chikunga had written a letter. I've just heard it from Mr. Dina Pillay.
Okay, so I'm looking for an insight, colleagues. Who does here? Because, and this is important because it would mean that a lot of the things that we are traversing, all of these things about board notice XYZ, the accounting standards issue, and so on, basically it would appear that those ministers did not do much. And I don't want to reach that conclusion unfairly if they opted for meetings. If you don't know, you don't. I'm looking for somebody who would have an insight. So I'm understanding you to be saying you've been there for a year. Advocate, in terms of your role, is this something that you interacted with? You didn't?
No, no, Chairperson. If I did, it would be something that would have come up as either a court application or when one peruses papers.
Okay.
And that letter would have been attached or correspondence.
I see.
Yeah.
Okay. All right, colleagues. Any of you know to this question?
Chairperson, we don't have an answer, but I know that there was a meeting. Minister Chikunga had a meeting with the CEO and the board to understand this issue of an accounting standard. But unfortunately, we were not party to that meeting. But I know that there was a meeting to discuss that.
Okay, no, thank you. So can you just please note then that what we'll need, so apart from correspondence, if there are any minutes of meetings between the minister and the RAF, apart from the AGM, right? There is an AGM, right? Yeah, the AGM is always interesting. There's one shareholder. So any record of meetings, that's the first. The second thing, if you can assist the secretariat, if you know, with the name of the person who played your role prior to you. You've been there for a year, right? So, and we're asking questions going back to 2020, 21. And so, because we do need to get this answer, as we said, we also trying to understand, we're also assessing ministerial oversight here. And to find, that there was hardly any correspondences concerning. I have, as we watch the time, can you, I just have two questions, and these are general questions. What is, so who advises the minister, and I'm not looking for a name, I'm looking for the role, okay? Who advises the minister on the process of appointing board members and the chief executive of the RAF? Which position in the ministry is that? In the department, sorry. And the ministry.
So the person that is responsible for running with the board appointment process and advisory role, that would be myself as the current acting DDG.
Just name the role.
Okay.
I'm really not looking for a personality here, like
So
just the role.
it would be the head of the branch, who's the acting DDG. But within that branch, there is a chief directorate called corporate governance. It's a new role that came about when the DPE was then transferred to the department. But then before that, there's a directorate called corporate governance. That's where I was. That is the function that runs the entire process of board appointments and would then also advise the minister on the appointments, run the entire process and do a submission for the minister's approval.
Okay, so who goes through the list? So there's always an ad, and shame, I suspect you get 800 applications. Who does the shortlisting? By the way, on a lighter note, in the factory I worked at in Utnake, they were looking for the marketing director, and the Labor Relations Act says you must advertise internally. I think they got like 250 applications, and most of them were not in marketing. So anyway, could be. So who does the shortlisting? Is there a panel? Is there? That's all. Again, not names. I'm just trying to understand process here.
Thank you, Chairperson. So I think let me first start by saying that the RAF Act is not very descriptive in terms of the process. All it outlines is the advert and that we must publish the nomination received and the people that have been appointed. But for transparency and best practice, what we do is at the time when we need to go for the recruitment process, we do a submission to the minister and make a recommendation for the people, a panel to be appointed as the nomination and selection committee. Ordinarily, that would be the committee that will do the shortlist, and if there's a need, do interviews, and then after that, we will do the pre-screening, and then make a recommendation to the minister. But also what we have seen is different ministers, because it's not a legislative process, they would prefer different processes. So ordinarily, that is the process that we would follow. There's a committee that is approved by the minister to do the shortlisting and the interview process and the recommendation.
Okay, thanks. So is there a template of what the different combinations on the board need to be? In other words, it might be that you need a lawyer, and the lawyer has, I need that criteria, and I'm mindful of your time, so so just give me straight answers, because
Yes, Chairperson,
what does that look like, the template? I mean, not look like, but what's in it?
So normally what we do before anything else, we look at the Act. The Act is also very expressive in terms of the skills that is required in the board. Right, so section 10, I'm looking for that. Section 10, 1B, it talks about the skills that are needed. So that will be insurance, finance, medical service, provision, law, accounting, and actuarial science, or matters relating to disabled persons, road users, commuters, or consumer interests. So basically those are the skills that we will look into when we are doing our shortlisting. Then there'll be other criteria. We'll look at how many years you've been in a board. We'll also look at, we look for people that are board members as a career list, because we don't want a lot of people that are sitting in many boards to come to the road accident fund. So those are some of the criteria that we'll look into. So the committee will look at what the Act says, what it is in the advert, and also add on, because you can find that you can get 10 people that have medical expertise. Then we'll then develop other criteria that we will do the scoring on.
All right. So, and we'll come to the Chief Executive just now. Would you agree that with the benefit of the conversation that we've just had here, and the size and of the RAF and the importance of systems, I don't know if IT is mentioned in the Act, but would you agree that it might be a good idea to have an IT person in the board? Has that conversation come up as far as you know? That's one. The second relates to somebody with industrial or process engineering experience. I mean, you were here, we were talking about this, about how you can make the process seamless. Where do things fall apart? That's what those people do. So what I'm trying to establish is that, do you only look strictly at the Act, or I'm trying to understand the gaps that we've seen.
Thanks, Chairperson. So the first prize is to ensure that we meet those skills in terms of the Act. And then we'll also look at the challenges that the entity is currently facing. Yes, you are correct. In the last, was it 2022? We had a vacancy, and the department at the time, together with the engagement we had with the entity, we felt that indeed the department needed, the entity needed someone with the IT skill in the board. And also because at that time IT governance was also becoming a very prevalent matter. There was cyber security, and we really felt that the entity also needed to take the matters of IT governance into consideration, and we did appoint somebody into who had that IT skill. So we do look at those other challenges that the entity is facing, and we come up with a skill that is needed outside of the, in addition to what the Act requires us to.
Do you look for executive experience, executive management experience in the board members? Let me be transparent about where I'm going. So one of the reasons we're having an inquiry is that I looked at the organogram of the Road Accident Fund in the annual report. I cannot believe the vacancies that are there. They make no sense, right? There's no chief claims officer. There's no head of legal. The chief HR officer reports to someone else, which might give you certain problems. I can go on and on, right? just as a question, you don't need to account for those things. I'm asking, in the criteria, do you look for people with a certain level of executive experience? The Road Accident Fund is a 50 billion a year entity, correct, in terms of the transfers that it gets from the fuel levy. Are those kind of comparisons made? In other words, has this been the board member of an SMME, or has this person been a board of a 50 billion rand, 30 billion rand maybe entity, okay, even 10 billion, you know what I mean? Because people come, they oversee these entities as board members, and they've got no clue what they're doing. And they come here and we see an organogram in the annual report, and you think how the Road Accident Fund deals with two matters in the main. It's litigation and claims. And for more than 2 years, the roles are vacant. You don't need to answer to that specifically. I'm just asking, because that is then the thing that it triggers in my head, that these people don't appear to understand why strategically it's so important to fill these vacancies ASAP. When we link it to the question about the minister, I also expect the minister, if not him or her, to get advice from the person who says, Minister, I'm sorry, it's been 11 months now. This is vacant. This is why this place is collapsing. You get me? So that's why I'm asking this question about executive experience. Is it something that in your knowledge it gets looked at? And we're going to release you shortly.
Chairperson, in my knowledge and of the RAF as well as other board, these are some of the things that we really look into. But again...
You really or rarely?
We really look into. And our role is to make a recommendation. How that recommendation is received is but that's what the panel does look into. They look at the extensive experience. And the other thing is we would also just probably do a small search on those people that are being recommended, especially on their profile, the boards that they've served into. How do those entities perform while they were in those entities? So those are some of the things that we'll look into.
Final. So let me ask this: could you send to us, please record, Denzel, the score sheet that the panel uses? So it doesn't have to be filled in, you understand, just the template, the score sheet that the panel uses in evaluating board members. So I just want us to look, you understand, so the panel will be choosing people and their boxes to tick, you understand. So board experience below 5 years or more than 5 years, I'm assuming there's some criteria like that which helps you work through as you evaluate who to recommend to the minister, right? So I'm assuming there is a document like that. No?
Chairperson, we don't have a standardized template. So each panel, because there's different panels appointed at different times, so each panel will come up with their own criteria for that specific board or vacancy that they are filling. So we don't have a standardized scoring or shortlisting template. We do not have.
Okay, can you then just send us to the extent that there was one for the previous two boards, look for it. If they don't look the same, it's fine, right? And also, could you just locate the names of the panelists? The people whose names were on the panel. So we'd like to see those. I hope you understand why this is critical. You do.
Chairperson, I do.
Okay.
Yes, we will look into it to check if there was a panel and who the panel members were.
Okay, finally, is the same process followed with regards to, is there some guideline with regards to the appointment of the chief executive? This is what happened with the appointment of the previous chief executive. The ad was on the 23rd of April. The 23rd was a Thursday. It expired on the 27th. The 27th is a public holiday and a Monday, somewhere thereabouts, right? Which means it really was only like a couple of days for anybody to apply, right? And it appears to me that it's not a real thing, right? Because you're literally giving very little time for that advertisement to be responded to. It's literally 2 days. It's a Thursday and the Friday. Saturday, Sunday is a weekend. Monday is a public holiday. And the ad closes. So if you, all I'm asking is, because the board of the Road Accident Fund recommends to the minister, right? The minister may reject that appointment and maybe say, ask for someone else. Is there something that guides the minister in terms of evaluating the board's recommendation? No, if you don't know, you don't know. I mean, I'm just asking, does it exist?
Chairperson, no, there is no framework or a guideline that exists that guides the minister in terms of how, whether to make that appointment or to accept that recommendation. There is no. But the unit will look into the recommendation received, look at the process that has been followed, look into the minutes, how the scoring were done, the questions that were asked, and all those tests and the reports, and make a recommendation based on the information that is available.
All right, so the last thing, and then I'll release you. So apart from the quarterly reports and so on, when the minister sees, or any of you in the ministry sees an alarming report, so some of the things that would trigger us, for instance, is a letter from Judge Sutherland, basically at his wit's end, saying the Road Accident Fund cases are clogging my court. I just can't. You know the story. If you enroll a case now, they will hear it. I don't know, after these interventions that you guys have tried, they will hear it in 2030. You'll get a date in 2030 on a civil matter, on the civil roll, right? Which means the administration of justice is suffering as a result of the entity. So I am going, that's one of the reasons I was asking about how the minister oversees these things. Is it something that in the ordinary course, those kind of things are brought to the attention of the minister in order to solicit a response, or it's just left? I mean, what happens in the ministers, in the department ecosystem, department ministry ecosystem, when there is some incident, and this is one of them? No, I just want to know if there is some, I mean, somebody's got to bring these things to the attention of the, I would, if I was in the minister's office, I would say, hey, minister, we need to, does that happen? And that's my final question, I swear.
The answer is yes, it does happen. And it happens a lot of times where either of us, if we pick up anything that the minister needs to urgently act on, it will be brought to her attention for her to act upon.
Okay, so we will ask for specific information in relation to several things that have a kind of dog at the RAF. But I really don't want you to miss your flight. I don't, and I don't want you to drive like maniacs on the way to the airport.
No, thanks, Chairperson. Just to add, there is what is termed MINCO, in terms of correspondence that minister would receive from stakeholders outside. If it relates to something that pertains to, for example, the RAF and the branch that I'm falling in, there would be timelines within which we would need to respond to the issue at hand. So minister takes those kind of matters seriously, because in the end, we would need to prepare communication that if she is in agreement with the contents thereof, she would sign off as a response to whoever.
I was just asking about ministers in general. Remember that story we had about one letter each, you know?
Yeah, no, true.
So
no, Chairperson, I just wanted to confirm that.
Okay.
Yeah.
All right.
Yes.
No, Honorable Madlala, final question. Honorable Nilmay, final question.
No, thank you. No, thank you, Chair. It's not a question from myself. It is actually to request that, well, it's unfortunate that we don't have enough time, but I think we'll write to request further information. But one of that, what I would like you guys to provide us with is the delegations of authority framework from the minister to yourselves, to the board, to executive management, up until, okay, maybe let's say it until executive management. So obviously it will be a spreadsheet. Not rhetorical issues. The source, in which legislation it comes from. This is the kind of decisions, strategic, governance, whatever kind of decisions that can be taken by who. Because what we saw from the issue of the accounting standards were issues of uncertainty about who has the right to take what decision. And we need to clarify that as a systems issue, whether this decision lies with the minister, and we must then say if it's the minister's responsibility to take that decision. If the minister does not, what becomes the repercussions? Because you can't have two sections of power, sides struggling to find each other, and it goes on for a very long time. It should be a lesson that never happens. And then lastly, as an administrative issue, I just want you to go back and look into your presentation, colleagues. It is very unorganized. If I tell you, if you look at slide 8, there is where you speak about for the following 2.3.2. You say 4 important amendments included, and then you list things. But then you just continue with the same numbering. You don't then differentiate. This is just basic administrative issue. And then also, if you look at it was slide number 10, if I'm not mistaken. In fact, slide number 9, you have a repetition of 3 lines on 3 occasions, following each other. And I think at your level, just look into it, professionalize it, and I'm saying for future purposes as well, because it says quite a lot about how you pay attention to detail. Thank you.
Thank you very much, Honorable Beasley. Parting shot, or you fine? Was it you?
It was me.
Oh, it was Honorable Neil May. Okay.
Yeah, my parting shot is that, not for today, but did you say corporate governance? So corporate governance is where a lot of that selection and that takes place. What is the role of corporate governance in monitoring your entities? And at what stage does those reports and monitoring reports and the reports that come from all the AGMs and that get compiled and sent to the minister? And what kind of monitoring mechanisms do you have in that directorate or that department that actually can immediately flag where there are challenges? Not for today, but I mean, that is something we're interested to know, because you kept saying it's corporate governance that does the recommendations, does the filtering. So I'm interested to know, going forward, how does that directorate feed the oversight and monitoring of the governance aspects of your entities?
Thank you very much. Colleagues, thank you so much. We will then, I've made some requests. We'll just make sure that between the Secretariat and you guys, you're quite certain about what's needed, including those things that you must just please go and look for, the minutes or some other record of whether there were meetings or not. The honorable members, it's been a very long day. Thank you very much for your patience. Thank you to the team. And thank you, colleagues. I know you waited all day to be, and now you're almost missing your flight, so please, safe travels. And I hope it's not too full there by the security. Just drop my name there. Drop my name and just keep moving. Yeah. Thank you so much.